May I be permitted to mention one listed motion, which that health assistant female home district transfer. This matter was appearing before Justice Shogoto Bhattacharya, my lord, directed this matter to be to appear on 25th March. Because of the change of determination, the file has gone down to the department. This is
Give the
order.
number.
The order is also annexed.
This similar nature of this is the matter of heading of hearing, but it is listed in motion 1.
Heading of hearing cannot be done now.
So you want to prepare for release the matter.
No, it cannot be released either. You have to wait. Yes.
My lord, may I be permitted to mention a matter for inclusion in the list? My lord, the aforesaid matter was lastly appeared on 30 January of 2026 before Honorable Justice Arinda Mukherjee. This matter was supposed to come in the monthly list of March, but it did not come, my lord.
When I take up matters for inclusion, please mention then. All right.
Your lordship may be permitted to mention one matter. My petitioner is extremely old and age-old. He is entitled to retirement benefits, your lordship, but the benefits which has been disbursed to him actually wrongly calculated. So I'm praying for the inclusion in the list, madam, for the hearing.
When I take up matters for inclusion, please mention. Call the list, please.
Your lordship.
Direction.
Give.
Your lordship, may I be permitted to mention a service matter? Actually, the case is related to the removal of the CRPF personnel, and actually he is in a stage of he's in the verge of retirement. And if the case is not taken up, it will cause a grave injustice to the petitioner, and he is actually withheld from the salary also. Since 2022, he is withheld from salary. He is facing mental agony right now.
Yes.
So kindly be included in the daily list, my lord.
No, sorry, not now. Call the list, please.
My lord, may I be permitted to mention one matter small? My lord, I am supposed to be elevated to the rank of DIG, my lord, in the BSF, my lord. My lord, they were conducting a flimsy inquiry for last 4 years, my lord. Now, suddenly, my lord, all of a sudden, 2 days back, they have actually attached me with a disciplinary proceeding, my lord. This is a matter of grave urgency, because as per the DOPT guideline, if I am attached for this particular disciplinary proceeding, this promotion will be withheld, my lord. This is a performance promotion, my lord.
I am
My lord,
not
we are praying
accepting your
for
prayer now. Whenever I take up
special
matters for inclusion,
leave.
please mention. Yes.
No, my lord, it's a
My
Yes.
application is the Red Cross Society, Mr. Choudhury. Hey, Chatterjee. Mr. Chatterjee has taken his time to give instruction.
Yes, he is assisted by Mr. Kiran Sheikh and Syed Hussain. Where are they?
That I don't find him.
Call them. Call them. I'm passing it over. In case you come within time, then I'll take it over. Otherwise, the matter will be there in the list. You call somebody at least.
Okay. I'm
Yes.
taking a telephone call.
Yes, please.
Call.
Lordship, Mr. Devdatta Basu is appearing for the petitioner. Due to medical urgency, he is unable to appear the court, and I am praying for not this week, my lord.
Not this week.
My lord.
Are you aware as to whether the affidavit in opposition has been filed or not?
No, my lordship.
কালকে কে mention করলো? Oh, he mentioned it and he is not present. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. On such prayer, the hearing of the matter stands adjourned. Stop. Released on 6th April.
There's no application before you, Lordship.
Yes.
Well, this is a matter where the petitioner before your Lordship was a clerk in the United Bank, erstwhile United Bank of India. Now, sometime in the 90s, he was charge sheeted in 1994, and thereafter he was dismissed from service. Now, he preferred an appeal which was kept pending till 2012. We came up before this court, Honorable Court, and on the orders of the Honorable Court, the appeal was heard and was disposed of. Now, in the meantime, of course, they had filed a criminal case against me. And this criminal case resulted in acquittal.
Acquittal.
Yes, total acquittal. And that was before the disposal of the appeal. So the appellate authority, he knew that I had been acquitted of the criminal proceeding. but he did not take any, he did not take cognizance of that. And he kept the order of the disciplinary authority intact. That was dismissal from service. Now, if your lordship kindly comes to, now I will be going to the jurisdiction because of the fact that there are certain particular instances, particular clauses in the bipartite agreements of the banks, where it is once I am acquitted of the charges, then an order of dismissal cannot be sustained.
Please show me that.
Yes, minute. First, may I show your lordship the order of the disciplinary authority?
Yes.
That is at page 35.
Why don't you take your seat? Please sit down.
Well, my junior has not come. My junior has not come. That's
Okay.
why I'm feeling some difficulty because
Let him make his submission today. In case you want, I'll hear you on the next day. Yes, 35.
Now, if your lordship kindly comes, 35 is the order which starts, and then after that, they say financial loss, etc. They couldn't prove it in the criminal case. Now, if your lordship kindly comes to page 36, all considered, second, this is second paragraph.
Yes.
All considered, I find that a proposed punishment of dismissal from without notice in terms of clause 19.6 of the bipartite settlement dated 19/10/1966 has been just and proper in view of the misconduct which is of grave and serious nature proved against you. So that is during the period now 6 is very important. During the period of suspension, you are not entitled to any pay and allowances save and except which have been paid to you by way of subsistence allowance, and the period of suspension will not be considered as qualifying service for all purposes. Now, after that, if your lordship kindly comes to the appellate order, page 64. Now, I was, if your lordship calls upon me, I will place the acquittal, order of acquittal, but that is accepted. I'll anyway, I have to go there. I'll have to anyway put that thing on before your lordship. Page 64. These are charges in brief, etc. He goes on, and then after that, if your lordship kindly comes to page 66 once. 4. Page 66, 4. The management should have, this is what I submitted before them. The management should have stayed the departmental proceeding inquiry when trial into the criminal offense had begun, with the submission of the charge sheet being number so and so, and as such, order of dismissal as such as is without jurisdiction for clause 19.4 of the bipartite settlement of 1966 provides as follows. I need not go into that. They have taken the cudgels, they have dismissed me from service. Now, this would be late. This would be, I can't agitate this point now. But they did violate the agreement. But anyway, now, if your lordship kindly comes, page 67. Now, this is something which is not really correct. Page 66, paragraph 5. I just read this. The penalty of dismissal without notice imposed by the disciplinary authority. Lordship's got it.
Yes, yes.
Yes. On 25/3/1999 was in terms of clause 19.6a bipartite settlement dated 19/10/1966 and was based on proven charges in the inquiry, and thus the contention of Shri Nityaranjan Mullik vide his undated letter that the order of his dismissal by the DA is illegal on the grounds of clause 19.3c and 19.4 is not tenable. Now, thereafter, the claim of Shri Nityaranjan Mullik CSE with regard to subsistence allowance was dealt with in the DA's final order, and there is no remark regarding his subsistence allowance being paid in terms of West Bengal Payment of Subsistence Allowance Act as claimed. From above, it is to inform Shri Mullik that no additional relevant documents were produced despite oral and written request in this regard, which was also directed by Honorable Court with a order dated 14/8/2023. For the reasons as stated above, I, being the competent authority, appellate authority, is unable to find any fresh ground for interfering with the order of the disciplinary authority. Accordingly, in compliance with the order of Honorable Court at Calcutta dated so and so, I pass the following order. I observe that there is no merit in the contentions raised by the appellant to warrant modification in the penalty imposed by the disciplinary authority. Hence, I reject the appeal. Now, this is what they say. Now, if your lordship sees the order is dated February 16, 2024.
Appellate authorities.
Yes.
All right.
Yes. Now, if your lordship kindly sees the order passed in the criminal case, that is at page 50. Now, this is dated 12/3/2010. Page 50. And if your lordship sees, I'll also take your lordship to the last page of this order. That the accused Nityaranjan Mullik is held not guilty of the charges under section 409, 420, 467, etc. Thus, he is acquitted from this case under section 235(1) CRPC. He is also discharged from his bail bond and be set at liberty at once. Now, the final order, if your lordship kindly sees, is at page 63. Why I'm saying this is because this might be pressed in service by him, so I might as well canvass this before your lordship. Page 63. I need not trouble your lordship. If it's said something is said about this, I will definitely reply. But if your lordship sees, I have no hesitation to hold that the prosecution has failed to bring home the charges against the accused beyond any shadow of reasonable doubt. Consequently, the accused is entitled to get benefit of doubt.
You show me the bipartite agreement.
Yes.
Please.
Now I will come to the bipartite agreement. If your lordship can. Wait a minute.
Is it annexed somewhere?
No, lordship, it's not annexed.
All right.
I've lost one of these books also to the court. I've not got it back. There, 07 407. আমাকে পাঠ করে দেয় 19.3 and 19.4. 64. আমারটা the 19.4 minute.
Yes.
If after steps have been taken to prosecute an employee or get him prosecuted. Your lordship's got it.
Yes, yes.
For an offense, he is not put on trial within a year of the commission of the offense. The management may deal with him as if he had committed an act of gross misconduct or of minor misconduct as defined below, provided that if the authority which was to start prosecution proceedings refuses to do so or come to the conclusion that there is no case for prosecution, it shall be open to the management to proceed against the employee under the provisions set out below in clauses 1911 and 1912 infra relating to discharge. But he shall be deemed to have been on duty during the period of suspension. This goes against the order, if any, and shall be entitled to the full wages and allowances and to all other privileges for such period. In the event of the management deciding after inquiry not to continue him in service, he shall be liable only for termination with 3 months pay and allowances in lieu of notice as provided in 19.3 supra. If within the pendency of the proceedings thus instituted, he is put on trial, such proceedings shall be stayed pending the completion of the trial, after which the provisions mentioned in 19.3 above shall apply. Now, if your lordship sees, uh, 19.3, this is, if he, your lordship, I've got a different book actually, that's why that book is lost. If he be acquitted, 19.3. If he be acquitted, it shall be open to the management to proceed against him under the provisions set out below in 1911 and 1912 infra relating to discharges. However, in the event the management deciding after inquiry not to continue him in service, he shall be liable only for termination of service with 3 months pay and allowances in lieu of notice, and he shall be deemed to have been on duty during the period of suspension, if any, and shall be entitled to full pay and allowances minus such a subsistence allowance as he has drawn, and to all other privileges for the period of suspension, provided that if he be acquitted by being given the benefit of doubt, he shall be paid such portion of such pay and allowances as the management may deem proper, and the period of his absence shall not be treated as period spent on duty unless the management so directs. So this is the actual position before you. Then there are judgments. I'm supported by a few judgments of this, in fact, of this honorable court as well. That this now, if your lordship kindly comes, I may come to these judgments. After you point an even about the maintainability, that if he takes the point about maintainability of this,
His opposition must be on record.
yes, he has taken that.
Then
He
in
said
that case, you please argue, because he can always come up.
yes, he can. So, Millard, he might take this thing that
Maintainability of what? The writ
of this
petition.
writ petition.
All
I'd
right,
say that you, since he's a workman, you have to go
before the
for
tribunal.
Tribunal.
Yes.
So,
Tribunal was there. That is
yes,
Yes, yes,
I'm
yes.
fortified by a few judgments on
Please
this
show.
point. Millard, I'll start with Premier Automobiles, because it's clear. Now, by now, the cloud is being cleared. Now, there is an election on the
The writ court is not a complete bar in approaching, or what?
Yes, it is not, because of the fact that the rights of the dispute which has arisen here, not a dispute, whatever, the violation, because I've said it's without jurisdiction. Now, the violation of these bipartite agreements, these are not standing orders under the Industrial Disputes Act. If they were standing orders, certified, because your lordship knows that's a totally, then of course the rights would, the only remedy would be the Industrial Disputes Act, the tribunal. But if it arises from a bipartite agreement of this sort, which has got the status of a regulation, and which has, of course, which has to be adopted by the bank.
Mm.
And this is under the Banking Companies Acquisition and Transfer of Undertakings Act 1970. Now, if your lordship kindly comes to section 19. The board of directors of the bank is the ultimate authority which frames the regulations, and then they are placed before Parliament. So it does not arise as under in Premier Automobiles under the provisions of the Industrial Disputes Act. And that has been explained ultimately in 2009. All these are three judges bench. And in 2009, ultimately the cloud has been cleared that no, Premier Automobiles has been held to be sacrosanct.
All right.
Yes. Now, if your lordship kindly may I invite your lordship's attention to Premier Automobiles,
Yes.
the paragraph 10. And then I'll come to the summing up. And that summing up has been, there's been a lot of exposition on this summing up. But first minute, paragraph 10. In Doe Bridges, 1831, at page 859 are the famous and oft-quoted words of Lord Tenterden, CJ, saying, where an act creates an obligation and enforces the performance in a specified manner, we take it to be a general rule that performance cannot be enforced in any other manner. This passage was cited with approval by the Earl of Halsbury, LC, and Passmore versus Oswald Twistle, Urban District Council, AC, so-and-so, and by Lord Simmons at page 407 in the case of Cutler versus Wandsworth Stadium Limited. Classic enunciation of the law and classification of the cases in three classes was done by Wills J. with the precision which distinguished the utterances of that most accomplished lawyer in the case of Wolverton New Waterworks Company versus Hoxford, with his speech and say. The classes are enumerated thus. Now, these are the classes. There are three classes of cases in which a liability may be established by statute. There is that class where there is a liability existing at common law and which is only reenacted by the statute with a special form of remedy. There, unless the statute contains words necessarily excluding the common law remedy, the plaintiff has his election of proceeding either under the statute or at common law. Then there is a second class, which consists of those cases in which a statute has created a liability, but has given no special remedy for it. There, the party may adopt an action of debt or other remedy at common law to enforce it. The third class is where the statute creates a liability not existing at common law and gives also a particular remedy for enforcing it. With respect to the class, it has always been held that the party must adopt the form of remedy given by the statute. Now, this is the special statute we're talking about. The industrial...
This one, the bipartite agreement settlement, you say?
No, the industrial disputes. Third.
All right, industrial disputes is a special statute and you cannot go over there.
Is there.
Oh, I understand.
I'm just coming.
You please take your seat. Yes.
Just coming.
What you are trying to point out is that industrial disputes is a specified act and the petitioner cannot avail the benefit.
He can, if he wants to. It's election. Number two. Number two. Because
Yes.
the bipartite agreement does not bar the courts.
Why not?
Tribunals.
It does
Not.
No, the civil court. It does not. There is no remedy also provided.
All right.
So this is the second class. He's put on election. There is that class where there is a liability existing at common law. And this is the common law. And which is only reenacted by the statute with a special form of remedy. There, unless the statute contains words necessarily excluding the common law remedy, the plaintiff has his election of proceeding either under the statute or at common law. Then there is a second class which consists of those cases in which a statute has created a liability but has given no special remedy for it. There the party may adopt an action of debt or other remedy at common law to enforce it. Because when a statute is enacted, I can say it from craze that when a statute is enacted, it is as close to the common law as possible, unless the parliament thinks that no, there should be an absolute divorce. So unless that the special remedy and the special law creates an absolute divorce from the common law, then everything is provided, which we call a complete code, where alternative remedy does not exist. So that is the thing. But here, in this, there will be this form. Now, thereafter, paragraph 11. But let me go, let's read this. The judgment of the Court of Appeal, which was affirmed by the House of Lords in Passmore case, is reported in Peebles versus so-and-so. It was pointed out that the duty of a local authority under Section 15 of the Public Health Act 1875 to make such sewers as may be necessary for effectually draining their district for the purposes of the Act cannot be enforced by action for a mandamus. The only remedy for neglect of the duty being that given by Section 299 of the Act by complaint to the local government board. Lord Esher, MR, pointed out that the liability to make sewers was imposed by the statute. There was no such liability before it. The case, therefore, comes within the canon of construction that if a new obligation is imposed by statute and in the same statute a remedy is provided for non-fulfillment of the obligation, that is the only remedy. Lopes LJ further succinctly pointed out that Section 15 did not create any duty towards any particular individual, and Section 299 gives a specific remedy for the benefit of the locality at large. Thus, it should be noticed that the obligation imposed by the statute did not result in creation of any right in favor of any particular individual. Now, if I kindly come to paragraph 23. Now, this has been debated over and over again. 23. And ultimately, it has come to rest. To sum up, the principles applicable to the jurisdiction of the civil court in relation to an industrial dispute may be stated thus. If the dispute is not an industrial dispute, nor does it relate to enforcement of any other right under the Act, the remedy lies only in the civil court. If the dispute is an industrial dispute arising out of a right or liability under the general or common law and not under the Act, the jurisdiction of the civil court is alternative, leaving it to the election of the suitor concerned to choose his remedy for the relief which is competent to be granted in a particular remedy. If the industrial dispute relates to the enforcement of a right or an obligation created under the Act, then the only remedy available to the suitor is to get an adjudication under the Act. If the right which is sought to be enforced is a right created under the Act, such as Chapter 5A, then the remedy for its enforcement is either Section 33C or the raising of an industrial dispute, as the case may be. Now, this is where then paragraph 24, we may, however, in relation to principle 2 stated above, hasten to add that there will hardly be a dispute which will be an industrial dispute within the meaning of Section 2K of the Act, and yet will be one arising out of a right or liability under the general or common law only and not under the Act. Such a contingency, for example, may arise in regard to the dismissal of an unsponsored workman with a view in view of this provisions of law contained in Section 2A of the Act will be an industrial dispute, even though it may otherwise be an individual disputes. Civil courts, therefore, will hardly have an occasion to deal with the type of cases falling under Principle 2. Cases of industrial disputes, by and large, almost invariably are bound to be covered by Principle 3 stated above. Now, Principles 3 and 4, and all these things have been discussed Unnu Rajasthan today. Viju, 1995. Paragraph लिखा है? Paragraph लिखा है? नहीं. This is 1995 5 SCC 75. Now, paragraph 24, Millet. Premier Automobiles, 1976 1 SCC 496 was decided by a bench comprising A. Alagirishwamy, P.K. Goswami, and N.L. Untwalia. The court found that the dispute concerned therein involved adjudication of rights obligations created by the Industrial Disputes Act, which means that it fell under Principle 2. In Dhulabai, 1968 3 SCR 662. Even so, the court considered several decisions, English and Indian, on the subject and enunciated the following principles in paragraphs 23 and 24. To sum up, the principles applicable to the jurisdiction of the civil court.
It is the same thing that is
the
there.
same thing. And after that, we
Yes.
read this. 25. If the principle number 2, and particularly the qualifying statements in paragraph 24, that has given rise to a good amount of controversy. According to principle 2, if the dispute is an industrial dispute arising out of a right or liability under the general or common law and not under the Industrial Disputes Act, the jurisdiction of the civil court is alternative, and it is left to the person concerned either to approach the civil court or to have recourse to the machinery provided by the Industrial Disputes Act. But principle 2 does not stand alone. It is qualified by paragraph 24. Now, what does paragraph 24 say? It says, in view of the definition of industrial disputes in the Industrial Disputes Act, there will hardly be an industrial dispute arising exclusively out of a right or liability under the general or common law. Most of the industrial disputes will be disputes arising out of a right or liability under the Act. Dismissal of an unsponsored workman is an industrial dispute and not an industrial dispute unless, of course, it is espoused by the union of workmen or body of workmen. But Section 2A has made it an industrial dispute. Because of this, civil courts will hardly have any occasion to deal with this. Now, after that, if your lordship kindly comes to paragraph 26. Before we proceed to consider the effect and impact of paragraph 24 on principle 2 in paragraph 23, it would be appropriate to refer briefly to the decisions in paragraph 26 of the said judgment. We need not. Now, if your lordship kindly come to all these judgments are preferred. And Austin Distributors also, this was our High Court. Austin, if your lordship sees that, 1970 Lab IC, I've got that judgment. That is also in my favor. Now, your lordship kindly comes to paragraph 29. Now let us examine the facts of the appeal before us in the light of the principles adumbrated in Premier Automobiles 12. So the first thing to be noticed is the basis upon which the plaintiff's respondents have claimed the several reliefs in the suit. The basis is the violation of the certified standing orders in force in the appellant establishment. The basis is not the violation of any terms of contract of service entered into between the parties governed by the law of contract. At the same time, it must be said, no right or obligation created by the Industrial Disputes Act is sought to be enforced in the suit. Yet another circumstance is that the standing orders does not itself provide any forum for the enforcement of rights and liabilities created by the standing orders. The question that arises is whether such a suit falls under Principle 3 of Premier Automobiles or under Principle 2. We are of the opinion that it falls under Principle 3. The words under the Act in Principle 3 must, in our considered opinion, be understood as referring not only to Industrial Disputes Act, but also to sister enactments like Industrial Employment Standing Orders Act, which do not provide a special forum of their own for enforcement of the rights and liabilities created by them. Thus, a dispute involving the enforcement of the rights and liabilities created by the certified standing orders has necessarily got to be adjudicated only in the forums created by the Industrial Disputes Act, provided, of course, that such a dispute amount to an industrial dispute within the meaning of sections 2K and 2A of the Industrial Disputes Act, or such enactment says that such dispute shall be either treated as an individual industrial dispute or shall be adjudicated by any of the forums created by the Industrial Disputes Act. The civil courts have no jurisdiction to entertain such suits. In other words, a dispute arising between the employer and the workman under or for the enforcement of the industrial standing orders is an industrial dispute if it satisfies the requirements of 2K and or 2A of the Industrial Disputes Act and must be adjudicated in forums created by the Industrial Disputes Act alone. This would be so even if the dispute raised, etc. Now, so if your lordship has seen sister acts, it's clear. Now, this was further considered again at paragraph 35, the last one. Paragraph 35. We may now summarize the principles flowing from the above discussion. Where the dispute arises from general law of contract, where reliefs are claimed on the basis of general law of contract, a suit filed in a civil court cannot be said to be not maintainable, even though such a dispute may also constitute an industrial dispute with the meaning of section 2K. Where, however, the dispute involves recognition, observance, or enforcement of any of the rights or obligations created by the Industrial Disputes Act, the only remedy is to approach the forums created by the said act. Similarly, where the dispute involves the recognition, observance of enforcement of rights, obligations created by enactments like Industrial Disputes Employment Standing Orders, which are called sister enactments to industrial disputes and which do not provide forum for resolution of such disputes, the only remedy shall be to approach the forums created by the Industrial Disputes Act, provided they constitute industrial disputes within the meaning of 2K and 2A. So this is what is actually I've shown before your lordship the sister enactments also. So these are not what I'm talking about is that these are not certified standing orders. These are regulations, and the bank is state within the meaning of Article 12. Also, now we come to the next one. 2009 Millet SCC 2009 4 SCC 299. Paragraph 36 and 37. If an employer intends to enforce his constitutional rights or a right under a statutory regulation, the civil court will have necessary jurisdiction to try a suit. If, however, his rights, he claims his rights and corresponding obligation only in terms of the provisions of the Industrial Disputes Act or the sister laws, so-called, the civil court will have none. In this view of the matter, in our considered opinion, it would not be correct to contend that only because the employee concerned is also a workman within the meaning of the provisions of the 1947 Act or the conditions of his service are otherwise governed by the standing orders certified under the 1946 Act, ipso facto, the civil court will have no jurisdiction. This aspect of the matter has recently been considered by this court in Rajasthan SRTC versus Mohar Singh. The question as to whether the civil court's jurisdiction is barred or not must be determined having regard to the facts of each case. If the infringement of the standing orders or other provisions of the Industrial Disputes Act are alleged, the civil court's jurisdiction may be held to be barred. But if the suit is based on the violation of principles of common law or constitutional provisions or on other grounds, the civil court's jurisdiction may not be held to be barred. If no right is claimed under a special statute in terms whereof the jurisdiction of the civil court is barred, the civil court will have jurisdiction. Well, this is what is being. This is ultimately all the judgments were reviewed.
But
And
here all the
paragraph
discussions,
34. Paragraph 34.
all the discussions are whether the Industrial Disputes Act remedy is to be availed of or
Yes.
civil court remedy to be availed of. How come you approach the writ court? Because that is what the objection of the bank is.
Paragraph 32. No, he doesn't say that. He says that only industrial dispute.
Only industry. A writ
and-
court will not be,
Bid court doesn't
have any jurisdiction. It's not a
Don't
court.
define it as a court.
Right.
We've got plenary jurisdiction. Now, if your lordship kindly comes to paragraph 34. Paragraph 34 of this chapter. The appellant has noticed here and before the state within the meaning of Article 12 of the Constitution.
Mm.
If an act on its part is found to be wholly unreasonable or arbitrary, the same would be violative of Article 14 of the Constitution of India. This is where I come in. In certain situations, even gross violation of the principles of natural justice has been held to come within the ambit of Article 14.
Violation of the principle of natural justice, you are not harping.
I'm saying
You
it's
say-
jurisdiction. Have
Without
you violated your own?
without jurisdiction by whom?
By the appellate authority, because he had no choice. He had to reverse the order of the disciplinary authority
In view of
terms
the
of 19.
Acquittal.
Yes.
In view of the acquittal.
Yes. And the acquittal, of course, brings about other features. Now it's been clarified by a Supreme Court judgment here. But if I may read this, it has other connotations now. It goes further. 2025 SCC online SC 890 Maharana Pratap Singh. Thank you. We are not going to Haldighati, the Battle of Haldighati. But the thing is, here we have a lot of it.
Yes.
Now, if your lordship sees, I may just say one or two things, and I have stated that none of the complainants, they were supposed to be complainants. None of them were examined at the disciplinary inquiry. Two of them came before the criminal court, and they said, no, there was no tampering with our accounts. They said that. But anyway.
Who are the complainants? The consumers or what?
They were supposed to be bank, yes, they were supposed to be consumers. Yes, today we say that they were customers, yes.
Customers. All right.
They said that no, there was now no tampering. Now, Milad, paragraph 50.
Hmm.
I got the
50?
Yes, Milad. The judgment acquitting the appellant reveals that prosecution miserably failed. Your Lordship's got it.
Yes, yes.
The judgment acquitting the appellant reveals that the prosecution miserably failed to prove his case beyond reasonable doubt, as both the informant PW3 refused to identify the appellant in court. This discussion confirms that the appellant's acquittal was not based on mere technicalities. This will be a point which will be taken by him. In Ramlal Sutra, this court held that terms like benefit of doubt or honorably acquitted should not be treated as formalities. The court's duty is to focus on the substance of the judgment rather than the terminology used. So this is very important. And paragraph 47. We read in 43. It's not germane now. That's over. 47, if your Lordship's please. While an acquittal in a criminal case does not automatically entitle the accused to have an order setting aside of his dismissal from public service following disciplinary proceedings, it is well established that when the charges, evidence, witnesses, and circumstances, both the departmental inquiry and the criminal proceedings are identical or similar, substantially similar, the situation assumes a different context. In such cases, upholding the findings in the disciplinary proceedings would be unjust, unfair, and oppressive. This is a position settled by the decision in GM Tank, since reinforced by a decision of recent origin in Ramlal. So, but here, of course, this protection is inbuilt in the bipartite agreements, 1904. If he be acquitted, then no, the order of dismissal without notice cannot survive. So what he does is, when he upholds the dismissal without notice, the appellate authority, when he upholds that, he goes beyond his jurisdiction, because that is not a jurisdiction conferred upon him under the bipartite agreements. And these have almost statutory flavor. These are regulations. That is my humble submission before your Lordship, that this order of dismissal must be quashed.
I would like to see the provisions of the Industrial Disputes Act, whether you fall within the definition of workman or not.
Yes, I'll bring it.
And yes, and
yes, your Lordship wants to have a comprehensive. Yes, I'll bring it.
because you say
No,
that this is what the
And-
defense will be taken.
Yes, yes. And one more, because another thing then I might have to produce before your Lordship was also Mamad Noor, because I am going to jurisdiction. I'm not going to any other place. Now this,
Yes,
that would be clear.
only the jurisdiction. All right. When you would come back next?
Next week, ভুলে যাবেন না?
Submission,
Next week, my
submissions made on behalf of the petitioner. Step 6 for further argument by the petitioner on বলুন আজকে হচ্ছে মঙ্গলবার, but next Tuesday I keep it 31st.
Deeply obliged.
You won't take much time, only
No,
little bit as a
I have almost
the bank. Yes, you have finished.
only.
I would like to have a photocopy of the standing orders also. Not the standing orders, the bipartite agreement.
I would
With
not
the-
like to keep that book again.
Take
because-
the book back.
Yes, I'll give you.
Photocopy with the
Sure.
first page of the agreement,
Yes, yes,
right?
First-
Otherwise, I won't get to
Yes,
know where from are you getting it.
But,
31st. Password আছে? আছে ডাকুন, আছে?
deeply obliged.
I'm praying for not to the lordship, possible matter I do not see lordship.
On behalf of,
On behalf of Advocate Shobhashwati Chatterjee lordship.
where is he?
He is engaging before Honorable Supreme Court lordship.
He should have kept somebody over here The matter, nobody was there for the Red Cross. I called for him and now he's not available. Yeah, I can see so many juniors assisting him. Why didn't you send somebody over here?
Lordship, please kindly, Lordship.
Only not today.
Yes, Lordship. Only not today, Lordship.
But can it be possible to fix that Friday?
Again, see,
Sorry.
you never know he'll be available or not.
Tomorrow.
Grateful, Lord.
Tomorrow.
I will be here. But
Hmm.
what is important, your other side's presence.
No, তুই তো বললি Friday. Well,
Lordship, item number 6, Devdatta Basu is appearing. Please kindly note this week.
Item number 6 has not been called on. So please don't mention.
Grateful.
Item number 1, my lord. I am for the petitioner, my lord. My lord, this is for correction, my lord. My lord, I am the headmistress, my lord. The direction is there, my lord. Head of the institution, my lord. Institute of Commissioner of School Education. And my lord, second page, paragraph.
I didn't follow. Which portion?
My lord, paragraph number 3, my lord.
Yes.
Paragraph. She made an application seeking transfer before the head of the institution. Lord, I am the headmistress.
Oh. So you made application before the Commissioner of School Education?
Yes, my lord. My lord, paragraph number 5.
Which page is your application? Show me.
Lord, I made party, my lord. Commissioner of School Education, my lord.
Oh. Where is your application?
My lord, page number 48, my lord. Please. Yes.
Commissioner of School Education.
And my lord, paragraph number 5, my lord.
Terminate,
Also, my lord.
Pradeep. Paragraph 3. Head of the institution shall read as Commissioner of School Education. And
Paragraph number 5, my lord. Also, head of the institution, my lord.
paragraph 5.
The President of Managing Committee.
Same shall be
Head of the institution. Institute of President of Managing Committee, my lord.
জায়গা হবে President of the Managing Committee. These two places?
Yes. Sir.
Next.
Grateful.
my lord, I am for the petitioner.
My lord, in item number 2, my lord,
My lord, that's correct.
the name will be replaced, my lord. Name was, my lord, wrongly, my lord, written. My name will be, my lord.
Put in his name.
Is a naam tha.
All right, next.
Tell us there.
My lord, I am appearing on behalf of the petitioner, my lord.
Item number 3, I am for the Lordship. In the first paragraph, his candidature was cancelled. For termination of candidature.
The petitioner challenges the order of termination issued by the employer. It is not so.
It's a termination of the candidature. It was not the employee. Termination of the candidature. I'm showing your lordship.
And the order of termination.
Page number 68, lordship.
He was never employed.
No. Never employed.
Oh,
My lord, appointment was provided to me. Appointment letter, my lord.
Kindly come to paragraph, page number 68, lordship,
68.
of the writ petition.
Cancellation of candidature. Yes. Where is the appointment letter? Where is the appointment letter, you say, petitioner?
My lord, actually, we are never mentioned about this, my lord. My lord, I'm going through it, my lord, actually. Because we just heard about this like a minor correction, they said, my lord.
And another, lordship, another paragraph number 3, there is scope to, the no is missing, lordship.
There is no scope to pass any interim order. No is missing. Paragraph 3. And over here, challenges the order of termination of candidature of the petitioner by Coal India Limited. Issued by his employer will not be there. No scope. Anything else?
No, lordship. Great. নামটা তো আরেকটা আছে না। And in item number 4, lordship, same
1 minute. Let the file come. Same thing?
same thing.
All right.
However, that line is in paragraph number 3, that line is not there. It's okay, lordship. That there is,
All
it's not
right.
recorded. It's all right.
So it's only the first paragraph that will be changed. Only first paragraph. Yes.
Grateful.
Much obliged, my lord.
Why may I please, lordship, I am for the petitioner. Last occasion, somebody took time, my lord. I think Mr. Ramchandra Agarwal was taking time. My lord, in this matter, I appeared for the examination for 2025 for recruitment of CAPF, Central Armed Police Forces, conducted by the SSC. I appeared the computer-based examination. First, my lord, I indicate, my lord, that is my application, page 20 of my writ application. Page 20 of my writ application. This is my application form. My lord, clause number 26.1.
Yes.
Middle portion, clause number 26.1, type of the NCC certificate, NCC certificate. I have mentioned specifically along with the document evidence. Thereafter, I appeared the examination. I, my lord, scored very well. My lord, kindly come to page 22 of my writ application. My lord, 106.12055, the score. Now, after normalization, NCC bonus score 8. Left hand side, the score marks has been given for the NCC certificate. Well, thereafter, I appeared as PST PET. I qualified. Thereafter, I appeared medical examination. I qualified. Malada on 15 January 2026, the SSC published the result for the selected candidate, and the cutoff marks for set up for the selected candidate, I scored more than the cutoff mark. But they have not given me any recommendation for appointment or any withheld list, nothing. Nowhere my roll number and name has been featured in the selected candidate list. My lord, I made a representation before the.
Please show me the cutoff marks.
Yes, my lord. Kindly come to page 31 of my application. My lord, I am a candidate of my lord, Hooghly General District.
Hooghly.
General District unreserved category. Page 31. General District unreserved category CRPF. My lord, I am 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 14, 15. 17, 18 line. 18 line from the top, bottom. General District and reserve category. No. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 line from the bottom, page 31. CRPF, General District Unreserved Category 101.54088. This is the cutoff marks. I have qualified CRPF as well as BSF. BSF is page 30. General District Unreserved, bottom three clause 3, from the bottom. BSF,
101.
yes, 101.14065. I get more than that marks. I have qualified that last time panel candidate of the selected list, but they have not recommended me. I made a representation. Then on 17th February, they have uploaded the result for the all candidates who have not qualified. That I became surprised that the result shows. Kindly come to page 39 of my writ application. Here they have shows that I have produced NCC B certificate and my cutoff mark reduced 98.12055. Normalization score right hand side and the first column
Bonus score is 4.8.
Yes, certificate NCC B certificate.
You showed C certificate.
C certificate, but at the time of document verification, they qualified me. I produced the NCC C certificate. B, C, all certificate I have produced before that. That will show kindly DV status and DME RME result. Kindly have a look. Clause DV status qualified. I have produced as per my application. NCC C certificate I have produced, they have qualified. They have marked qualified.
What's the requirements, B or C?
Any. There is a, as per the notification of the recruitment, that there is a bonus marks for the several categories of certificates. If it is B certificate, then 3% of total marks. If C certificate, 5% of the total marks.
You got 8.
I got 8, as because I am the C certificate holder. And at the time of the document verification.
Your C certificate, have you annexed it?
Yes. That also before cutoff date.
Show me.
Yes, kindly come to page 19 of my writ application. That is my certificate. It was issued on 14 August 2024. Prior to notification and cutoff date. And B certificate, page 18 of my writ application, B certificate also is there. At the time of document verification, I produced both the certificates. They have marked that I have qualified in document verification, DB. But at the subsequently on 17 February 2026.
All right, I followed it.
Yes.
My lord, SSC New Delhi is the appropriate authority to deal with this matter. My lord, just now I have received the report, though the report is not very clear. My lord, I want to
you said what is there?
My lord, they needed some time. We have apprised them to give us a report as early as possible. My lord, because this particular part is being governed by this SSC New Delhi.
The petitioner participated for recruitment as GD
Constable GD. Central
in CAPF. Stop. She disclosed her NCC certificate in the application form. Stop. The petitioner has annexed the NCC B and C certificate in the writ petition at pages 18 and 19. अच्छा की बोललाम NCC application form में NCC C certificate. Only C certificate at the time of application and annexed both B and C in the application form. Acha. ডেটটা দিয়ে দিন তো NCC B certificate and C certificate dated 4th September 2023 and 14th August 2024 respectively. Stop. The petitioner was awarded 8 marks as NCC bonus score and final score was 106.12055. Stop. Her allegation is that despite qualifying in all stages of the selection process, appointment letter has not been issued in her favor. Recommendation for appointment has not been made in her favor. Stop. The petitioner has come to learn that she has been awarded 4.8 in the NCC bonus score, relying upon the NCC B certificate, and her normalized score, which has been taken into consideration by the authority, is 98.12055. Stop. The
Final no, my lord, final score is
final
left hand.
score
Is left
of
hand.
the petitioner has been found to be 102.92055. Stop. The lowest cutoff in the BSF category is 101.14065 and in CRPF 101.54088. Stop. Learned advocate for the petitioner submits that as the petitioner disclosed all her relevant certificates at the time of document verification, which is also reflected in the document uploaded by the authority to show the DV status of the petitioner. Accordingly, the final score of the petitioner being 106.12055 ought to be taken into consideration. Stop. Learned advocate representing the Union of India seeks time to revert with instructions. Stop. Paragraph. To allow the learned advocate representing the Union of India to revert with written instruction, hearing of the writ petition stands adjourned till how soon can you come back?
Well, fortnight.
13th of April.
I'm being led by Mr. Siddhartha Bhattacharya. His name will also be recorded.
He's not here. I don't see him over here. Why will his name be recorded?
That is instruction.
It's only your name that will go down. Affidavit of service taken on record.
Grateful.
Grateful to Lord.
7, my lord, I am for the petitioner being led by Mr. HON'BLE, my lord. My lord, I appear for that. Lord, this petitioner's father, my lord, was working as a Safai Kurmi, my lord, at Eastern Coalfields Limited. Subsequently, my lord, he died on 14th of January 2021. And my lord, immediately thereafter, I applied for compassionate employment in the said post. My lord, immediately, my lord, on 15th of January 2021, the very next day, I was asked to join the said post, my lord. Thereafter, my lord, the respondent authorities, my lord, directed me to appear before the initial medical board for examination, my lord. Therein, my lord, I was duly present on 25th of May, my lord. Only, my lord, I was asked to, my lord, submit certain documents, and thereafter I was asked to go outside, my lord. My lord, subsequently, now kindly considers, my lord, page 24. Page 24, my lord, the general manager, my lord, wrote to the CMO administration My lord, kindly sees, my lord, second paragraph.
Yes.
My lord, upon examination of the fact and materials on record, it is observed that Sri Gautam Hori candidate was examined in IME CH Kalla on 25th of May 2021 when he appears to be 33 to 38 years of age, and he was declared unfit for employment due to low vision 6/24 best corrected vision with glass and pinhole due to muscular scar in right eye. In this context, this is to state that Sri Gautam Hori is not eligible for employment as per provisions of NCWA and other guidelines of the company since he is found unfit for employment and overage. In view of the above, you are requested to terminate the candidate from his service immediately. This was the finding, my lord. Thereafter, my lord, I was communicated with the termination letter, the very next page, my lord, page 25.
Yes.
Challenging such examination report by the ECL authorities, my lord, I approached before the local district hospital situated at Asansol, my lord. Therein, my lord, kindly sees page 27. Page 27, my lord, I was declared as fit for joining in the said post. My lord, thereafter I made a prayer before the same authority to, my lord, resume my duty, my lord. That was not taken into consideration. I preferred this writ petition before this honorable court. Subsequently, my lord, after hearing me, my lord, the Honorable Justice Lopita Banerjee directed the Eastern Coalfields Limited to submit a report. They have submitted a report. Reply. They have submitted a report. Kindly comes to page, my lord, 10. Page 10 of the report, my lord.
Yes.
Initial medical board found to be 33 to 38 years, my lord. Kindly sees, my lord, page 10, the lower portion, age assessed as between 35 to 40. It increased, my lord.
1 minute. Where is it?
My lord, bottom portion, age assessed as between 35 to 40
All
years.
right.
This was, my lord. My lord, the next page, page 11, therein it was stated that unfit for employment due to low vision 6/24 such and such, my lord. It was also stated by the initial medical board, my lord. Now, my lord, since I have, by way of representation, I challenge this medical examination report, my lord, I was called before the Apex Medical Board. Kindly see page 13, my lord.
Yes.
Page 13, my lord, there was no indication of my low vision. Only I was stated that age assessed as between 35 to 40 years. This was the report, my lord. Kindly see the bottom portion, my lord.
Yes.
Now, my lord, your lordships kindly peruses the, my lord, order passed by the Honorable Justice Lopita Banerjee on 1st of March 2023.
You were sent to SSKM for ossification test.
Ossification test, but my lord, prior there to, if your lordships kindly consider, may I read out the relevant portion?
Why is it required at this stage?
My lord, it was required since your lordship on the other day asked me about
What?
the low vision. What
All
about
right.
the low vision? My lord, I am placing, my lord.
No, but then now you have showed me. Yesterday you were not in a position to show me the Apex Medical Board. Now you've showed
My
that
lord,
it is not there.
it
It
is
is
not
only
there.
the age.
My lord, and the Honorable Justice Lopita Banerjee also recorded in the order that that part is not there.
All right.
Thereafter, only the ossification, only with regard to the assessment of the age was taken into consideration.
All right.
Thereafter, ossification test was conducted before the SSK.
Show me the
before your
report.
lordship. Report is before your lordship.
Show me.
In the meantime, my lord, they preferred one recalling application. That was out of this order, my lord, of ossification test.
All right.
That was also dismissed.
All
They
right.
preferred an appeal before the division bench. That was also dismissed.
All right.
Thereafter, my lord, kindly seize the report, my lord. My age was assessed between 30 to 40 years, my lord.
Where do I get that?
My report of the SSK, my lord, please.
Is the report of the SSKM? Does it have a date?
My lord,
Yes, my lord. It was
my lord,
communicated by letter dated 28th of May 2020.
Right, this is the document.
Yes.
My
lord, kindly comes to page 3, my lord.
Page 3.
Opinion of the board on age of Gautam Hari, my lord.
Yes.
Considering all the relevant findings on radiological examination, we are with the opinion that the age of Gautam Hari is between 30 to 40 years. Now, my lord, the middle age is taken into account, 35 years. The maximum limit for joining under compassionate employment for a male candidate is 35 years. My lord, my father died on 2021. At 2022, I prefer the writ petition. So if my lord
No,
on
so you say that since the ossification test middle age is 35, you should be taken into
at
employment.
the
This is
time
your
of
case.
employment, I was 32 years of age. This is my case.
What is the age certificate that you are relying upon?
My lord, several, my lord, I have given. Kindly see the writ petition, my lord.
Do you have a school leaving certificate
My
or
lord,
anything
my
of
lord,
that sort?
my lord, kindly see, I have annexed everything, my lord. But they had not relied since.
All right, show me the school leaving certificate.
My lord,
Is it issued by the board?
no, my lord. Page 23, my lord. 23 onwards, my lord. But first, I have annexed the Aadhaar card.
No, no, Aadhaar is not the proof of age.
My lord, thereafter, my lord, I have annexed. My lord, I am saying what I have annexed. Thereafter, my lord, the PAN card. Thereafter, the voter card.
This is a school certificate.
My lord, transfer
You
certificate.
do not have a board certificate.
No, my lord.
All right.
Actually, my lord, he has not studied.
Yes,
so
I
far.
follow it. Yes.
But first of all, my lord, I have to rely upon the Mines rules and the Mines Act. Why we conduct, my lord, this IME, the initial medical examination, including the age assessment. My lord,
Go back over there.
well, it's
because
required because the matter of vision, which he is saying that we have said we have given a go by, or we have said that we have not said. That's for clarifying that I have to go back to that.
Why don't you place him in such a position where vision is not very important?
No, it's important, my lord, because under the Mines rules, there is a particular set, there is a particular, my lord, table which says what should be the vision, whether in the mines
You
or on the
place-
surface.
Yes. In some place, some position where vision may not be so much
We cannot do it, my lord, under the Mines Act and Mines rules. That's why I am
Sir,
referring to.
I
Well,
agree with you.
Kindly, maybe, my lord, but kindly, my lord, have a look at the Mines rules and the Mines Act.
Only one thing I may indicate, I am applying for Safai Kormi, my lord.
No, he cannot apply for a Safai Karmi.
My father was working as
Oh, my
Safai
lord,
Kormi. To that I was, my lord.
No, it's not that a Safai Karmi's son is to be appointed as a Safai Karmi.
All right, you
It's
place
a
him
general
somewhere.
employment. But first of all, my lord, kindly have a look at the Mines rules. It has to be. Because I have to distinguish, my learned friend has shown the documents. He is saying that first we assess 33 to 38 and thereafter 35 to 40. I have to, my lord, plead on that also. Now, first, my lord, Rule 29B.
29B.
It is mandatory, my lord, for us. My lord has got it. 29B. After such date or dates as the central government may by notification in the official gazette appoint in this behalf, the owner, agent or manager of every mine shall make arrangements. Now, my lord, we skip A because A is, no, my lord, is A, my lord, for the initial medical examination of every person employed in the mine, it is not applicable. My lord, next to A2, my lord, for the initial medical examination of every person seeking employment in a mine, unless such person has already undergone within the preceding 5 years a medical examination under these rules while in employment at another mine. And now, my lord, thereafter, 29F. F, standard and report of medical examination. The examining authority holding initial medical examination under subclause 1 of clause A or periodical medical examination under clause B of Rule 29B shall examine a person according to the standard laid down in Form P and the initial medical examination under subclause 2 of clause A of Rule 29B, of all persons seeking employment in a mine shall be according to the standard laid down in Form P1. Now, what does the P1 lay down, my lord? My lord, kindly come to the last page. Last but one. Form P1, column 4. It has set down the standards. The distant vision eye with or without glass should be not less than the following standard. My lord, there are two columns, my lord, for workers employed on surface and in open cast, and for workers employed below ground. Even if we say that we are not posting him below ground, but on the surface, what is the standard, my lord, for surface? Better eye is 6/12, worse eye is 6/18. Now, what is his vision now? We have found, my lord, kindly see. What is his vision? Kindly take up my report, my lord. Page 11 of my report. This is, kindly see.
Yes.
Unfit for employment due to low vision. What is the vision? The worst eye is 6/24. He was not within 6/18. Page 11 of my report.
Yes.
My lord, kindly see, unfit for employment due to
6/24.
6/24.
Hmm.
And that the standard set down, my lord,
Hmm.
as per the mine rules, is 6/18.
Hmm.
So I cannot take him.
All right.
6/18. This is one score. Now, my lord, so far, my lord, these two documents in this report, my lord, my learned friend has shown. One is 33 to 80,
Then
38.
page 13 of your report, the
I'm
apex
coming, my lord.
medical.
I'm coming, my lord.
All
I
right.
will come to that, my lord.
All right.
First, my lord, I distinguish, my lord, what my learned friend has said, that one we have found 33 to 38 and then 35 to 40.
No, that is the age.
Age, my lord,
So
this is the
that-
vision.
The vision.
So far, vision is concerned, my lord, I'm coming to that, my lord, because all are correlated. What happens, my lord? Because, let me, my lord, place another thing, 29J of this mine's rules, which is very important.
All right, I'll come to over there, page 11.
Because 29J says.
I am coming there. Page 11, you relied upon his vision is 6/24.
6/24.
All right.
6/24.
And page 13.
13, my lord, I am coming to 13 because all these are correlated, my lord. So
Yes,
one after
yes.
another, my lord. The sequence of events will prove it, my lord.
Mhm.
What is 10, my lord? Then the question might arise, what is 10 and what is 11? 10 is the other initial medical examinations and 11 is the 10 is the, my lord, kindly see.
10 rules.
Present age, he says, no. Present age is 33 years. And thereafter 11, my lord. 10, my lord, kindly see. This is the age assessment board.
Ten is the age assessment board.
10 is the age assessment board.
Huh?
It's only assessment of age. What
Right.
is the age assessed, my lord? Kindly come to the bottom. After radiological examinations, it's not that.
Yes.
Otherwise, age assessed as between 35 to 40 years. What is the date, my lord? 24th of May 2021. This is the date. Now, my lord. And 11 is the other initial medical examinations. So combining these two, the entire initial medical examination, and we gave a report. The hospital gave a report, my lord, this board gave a report. Basing on that, his candidature, his application, he was already appointed because there was a chaos in the mine of the union. So on that day that his father died, on that day he was given a provisional application subject to the condition that he fulfills the condition, other conditions. That's why, my lord, this age assessment and all these are after his provisional appointment. Now, my lord, we issued those letter of regret. That's my learned friend has already shown. Now, after we issued this letter of regret, what he does, he issues a letter. What letter? Now, my lord, this is in his writ petition. Page 26. What does he say? Kindly see. That's why I say, my lord, Rule 29J is very important.
26.
26. He says, with reference to your above letter, my lord, he is referring to the letter of regret, my lord. With reference to your above letter, I like to inform you that I have been offered provisional employment against the death, he says, death of my deceased father, late Suresh Hori, ex-Safai Karmachari at CH Kalla. Now, accordingly, I have performed my duty regularly with entire satisfaction of management. I am sorry to inform you that the competent authority has regretted my employment on the plea of unfit for employment due to low vision and overage as declared in IME held on 25/5/2021 at CH Kalla, and my service was terminated on and from 10/7/2021. Sir, in this connection, I like to inform you that as per my Aadhaar card, PAN card, as well as voter card, my date of birth has been recorded as 1/1/1988. The said date of birth, that is 1/1/1988, also corroborated with my transfer certificate, and I am only 33 years of age at present. I am enclosing also a copy of medical certificate issued by Medical Officer, District Hospital, Asansol, for determination of my medical fitness through Apex Medical Board of ECL, for determination of my medical fitness through Apex Medical Board of ECL. You are requested to consider my prayer sympathetically and allow me to resume my duty, since I am only 33 years of age and able to perform my duty as usual. I also belong to scheduled caste community. So nowhere he is saying that his vision is other than 6/24. Nowhere. He is giving stress only upon his age. Now, pursuant whereto, we constituted the Apex Medical Board. The Apex Medical Board thus tested his age, assessed his age within 2 or 3 months time, my lord, and your lordship will find it from page 13. The date is 19/4/2021.
Yes.
Now, my lord, this Apex, within a span of 2 or 3 months, my lord, his age was reassessed by Apex Medical Board, the same age found. So only it was age assessment, not vision. So the matter of vision does not go. Now, what certificate he has annexed? Now, my lord, kindly see. He's harping on that. What certificate he has annexed? That very next page of the writ petition is page 27. I would like to invite my learned friend to show that whether the certificate says that his vision is otherwise, when the certificate itself is by an ophthalmologist. Doesn't say so. Doesn't say so. That it's otherwise. It's not 6/24. He has never challenged that. He has never said so. Even in the writ petition, he has never challenged those medical reports of ours, my lord. But here, my lord, and kindly see, my lord, an ophthalmologist is saying that he's fit for duty. He's fit for duty. What purpose? We have not sent him to that ophthalmologist or that hospital, my lord. And my lord, kindly see the dates. It's a span of 2 years. 2 dates are there, my lord. Kindly see. Medical Officer, Asansol District Hospital. First is of 21/7/2021. Second is of 8/2022.
First is of page 27.
Page 27, there are 2 dates.
31st of July 2021 registered.
My lord, nothing.
At the top.
My lord, thereafter, my lord, kindly see. And thereafter, my lord, 3rd of August
2021, 3rd of August 2021.
Here, my lord, I cannot get anything, my lord. This is
When
the
I
copy
cannot
supplied.
get anything, but then I
But,
can think that this will be one.
Even if it is that, it is 31st of July and it is 3rd of August registration. Very well, my lord. But so far this certificate is concerned, my lord, how it can be given any weightage? An ophthalmologist is saying that he is fit for duty.
No, all right, not fit for duty, but then his eye vision is mentioned over his.
Mention what? Where it is 6/24. It is not saying that it's less than 6/24. It's better than 6/24.
It's 6/9. It is disclosed.
It is said
6/9 is
it's
mentioned.
looking 69. My lord, what I
It's
say?
6/9.
My lord, even then also, my lord. Even then also, my lord. We have also a report. They have. It is also a report based on only this, and there, my lord, in the ossification, it's only the ossification test which has been done. It was not done the
Page
vision.
13, page 13 of your report.
Yes.
Examination findings in both eyes. Normal. What does this mean to say?
Let me say.
Page 13. 19th of November 2021, left hand side, serial.
Normal.
All normal. How can you say that is I was not tested by
Very
the
well, even if I,
official
my lord,
report?
give it up this thing, my lord, so far is now age is concerned, my lord.
So that means you are not going with the IC
No,
report you
no,
give?
even if it is,
Because you are
This was the plea taken, my lord, before the Honorable Justice
Let
Lokita
me
Banerjee.
finish.
Now tactfully he is misleading your lordship.
No, my lord, this is very,
My lord,
I
am
take
saying,
it
my lord,
otherwise, my
because,
lord.
my lord,
I
this
have
was
never, my lord.
decided.
I have, no, no, no.
Since, my lord, if
don't
No, no, please,
kindly
please.
wait.
No, I take it
Please wait.
otherwise.
Please wait. All right.
So
Yes.
I am
Next.
giving it up now, my lord. So far the age is concerned, my lord. Then, my lord, only one thing I am left with, my lord. So far this is concerned, my lord. My lord, if your lordship kindly takes up this report, my lord, because we have a set of rules while assessing the age, and that is to be followed, my lord, because that rule says that the age.
See, the court's order directing ossification
Yes.
for verification of the
Yes,
age
yes.
was taken up in appeal and you've lost.
No,
So you
the
cannot
appeal-
raise the issue.
No, my lord, I am not on to that. Now, my lord, what I am saying that
Where is the order of the appeal court?
appeal court, my lord friend must be having with him.
The order of recalling application,
Yes.
my lord, this point was taken, this
What
mines
point?
and minerals, my lord, and appeal court of
Not Mines and Minerals, but only Mines Act.
mines and
Mines and Minerals is something.
Something else.
All right. And the division bench is order?
Division bench, my lord, only, my lord, is there that the single bench observation is right and we do not.
Says, my lord, says that
contradict,
he will not be prejudiced,
and
my
my lord,
lord.
one
It
thing,
will
my
not
lord,
be so far, I remember.
Act number?
All
All right, find it out and give.
That says that you will not be prejudiced if the ossification test is done.
Right.
You will not be prejudiced. So
Yes.
far, so that's why, my lord, that appeal was not entertained.
Right.
That's good. Now, my lord, what I submit today before your lordship, my lord, that this ossification test report, my lord, if your lordship takes it up, my lord, this says page 3, my lord.
Page 3, you showed me opinion of the board.
Yes. Considering all the relevant findings on radiological examination, we are with the opinion that the age of Gautam Huri is between 30 years and 40 years on the date of radiological examination, that is 12/4/2024. So the age range should be of 5 years because they are in a previous case, my lords, in the division bench also, not this matter, my lord, some other matter. I have a copy of that with me. On that score, my lord, set aside that ossification test report. Because it should be, because as per the guidelines, my lord, for providing employment under the NCWA, it is 5 years. The age range should be of 5 years. So that age range is to be taken. May I, my lord, place this order, my lord?
Assuming
Yes.
this is dated 2024. He was given a job in 21, right?
my lord.
3 years back.
Yes.
So the age will certainly be reduced to
No,
some
my
extent.
lord, obviously reduce if it is, my lord, on the range of 5 years. What I'm submitting
Even
today,
if it is in the range of 10 years, this 10 years range
my lord,
will
that
go
cannot
down.
be, because, my lord, in the medical jurisprudence, what happens, that each point is taken, my lord. For 5 years, for 10 years, there are several points, my lord. Those points are to be taken, my lord, as your lordships are well aware of these facts, my lord. So, in our view, my lord, so we have also conducted a test, they have also conducted a test. My lord, two things, my lord, may only, subject to your lordship's permission, my lord, may only suggest, my lord, but only can plead, my lord, that first of all, my lord, this is a 5 years range. Let there be a 5 years range ossification test and let it be by EMS. Let it by EMS.
How many time will you
One
test
time more, my lord.
person?
One time more, my lord. One time more.
Their intention is to not to give me the.
Well, otherwise, we would not.
My lord,
We would
because
not have, my lord. In none of the cases, we have provided the provisional appointment. Here, my lord, he was provided with provisional appointment.
only to, my lord, stop the chaos, my lord. Only to take
Now,
care of, my lord,
why did they make the chaos?
union, my lord.
Let
That
him
was done.
let
And
him answer.
subsequently, in a revenge
Why did
code,
they make?
this was done, my lord. And kindly considers one thing, my lord.
Let him show it from their pleadings,
If
my
I was
lord.
sent for ossification test, I should have been sent for, my lord, this low vision test also. My lord, that was not, because, my lord, on that plea was not.
I am
never
not on
taken
to the
single bench, my lord.
I am not on to the low vision right
Since I
now.
passed this ossification test, they are raising this new point. So that, my lord, I could not join.
Now, my lord,
my
very
age
well, my
expires.
lord. I hand up these two judgments.
Show me the decisions you are relying upon.
One. Just one, my lord. One is this, my lord, where the ossification test was set aside and it was ordered to be done again. In this matter, twice the ossification tests were set aside.
Here also see SSKM hospital was trusted.
No,
It's not
that
that-
matter, but now, my lord, we are saying that now in most of the matters, even our Honorable Chief Justice, when was taking the service matters appellate bench, my lord, was referring the matters to AIMS Kailani. There is another judgment, my lord, where, my lord, even after considering the ossification test, an order was passed by Justice Lobita Banerjee, and that was set aside.
No, that is
That
different.
that is different, my lord. That's why I'm not.
An order setting aside doesn't mean all orders will be set
No,
aside.
no, not that.
No,
But
then
it's
why
that
makes this
fast,
type of assumption?
my lord. He's
What was the reason for bringing down this range of this?
My lord, range, my lord, I said because our set of rules says that it should be within 5 years. It should be within 5 years to give more accuracy and correctness to the tests. We have the rules. I have the rules, my lord. May I hand up, my lord, one copy?
Which portion?
My lord, kindly see the first, second, third page. My lord, see guidelines for recording date of birth, assessment of age in Eastern Coalfields Limited. Thereafter, my lord, scope and turn to, if my lord turns to the next page, that is the fourth page, procedures. New appointees, my lord, A, B. First one is for the appointees who had passed matriculation, because who had passed the matriculation, we take the age as it is in the matriculation certificate. All the other appointees will be subjected to medical examination in the establishment area for determination of their age through a committee headed by the area medical officer or the constituted for the medical officer in charge of the establishment. The committee constituted for determination of age will indicate the age in a range of 5 years, and the midpoint of the said age range will be taken as authentic date of birth of the concerned appointee. So it should be in the range of 5 years.
So your prayer right now is for conducting
Let him be.
Second
Yes,
ossification.
because already there is an order of this court, my lord, honorable court, for ossification test, my lord.
But then has any ratio been laid down over here? I don't
My
see
lord,
any.
there is no ratio, my lord. I cannot say that there is a ratio, but it has a, my lord, persuasive value, and my lord, the honorable division bench held. Well, because these types of things, my lord, these types of cases do not generally occur, my lord. So this.
Was anybody from your side present at the time of ossification test of
In
the
this matter, my lord, that I have
present.
to.
Their officers
I
were
have to
present?
ascertain, my
That
lord.
was recorded in the order.
It
I
is
have to,
recorded.
my lord.
The authorities
No, if that be so,
Yes.
then that be so. If that be so, then that be so. Because report is in their hand. Was present was Deputy Manager, Jayashree Yadav, Deputy Manager.
Was present.
Yes.
Where is it?
Yes, my lord, kindly see that or 17.5, that first, second, third page, my lord. It starts, my lord. Gautam Hari was identified before the medical board on 12/4/2024 by Jayashree Yadav, Deputy Manager Personnel, Central Hospital, Kalla, Dev Shuddha Mitra, Senior Medical Specialist, Ortho, Central Hospital, ECL, Kalla. So
That means somebody from your side was also present.
Yes.
All right, let me see what can be done.
Because we have only given a report, my lord, because that's why the SRE, my lord, that is the their service excerpts, my lord, is not there, my lord, before your lordship, where they have also mentioned, my lord, what is the age. Because in the mines, my lord, every employee, my lord, who is getting an appointment, he is to sign a form, and there he is to make the declaration of his relations of his family and his age as on that date.
Hmm.
That also corroborates that he is more than 35 as on the date.
What is the corroboration? He has a wife and daughter. Somewhere it is shown.
He has a wife and a daughter.
And a daughter. What is
Yes.
the age? Does the age?
My lord, it's probably it's not annexed.
No, I
It's
saw
not annexed.
somewhere.
Probably it's not annexed. No, it's not annexed. The certificate of death and nothing is annexed there. Not annexed, my lord. Not annexed. Not annexed. It is not annexed, my lord.
All right, please come.
My lord, only I would like to add two things, my lord.
Yes.
My lord, first, my lord, the employees of the ECL are governed by National Coal Wages Agreement. My lord, I am placing this before your lordships. My lord, I only have one copy, 9.3.2. Your lordships kindly seize, my lord.
It says the above age limit is 35 years.
Yes, 9.3 point.
9.3.2, the bottom portion, my lord.
9.3.3.
When, my lord, the deceased, the heirs of the deceased employee can be, my lord, appointed. That is there, my lord. And secondly, my lord,
9 point workman's benefit.
my lord, the
9 point the dependent for this purpose means wife.
Son.
Employment to one dependent who is permanently disabled. 9.3. Which one are you?
9.3.4, my lord. Next page.
3.4. Yes. Dependent to be considered not more than 35 years.
My lord. They are themselves confused with my age. Once they are saying
What he's submitting, what
thereafter
he's submitting,
35 to 40
what
years.
is the relation with this? We are not denying. But what he's submitting, there must be some correlation between the two.
Somehow show me above 35.
35. It
No,
should
no.
be 35 years.
I have not said that is not 30. I am also saying it's the upper age
saying
limit
that
35 years. What he's
35.
submitting.
My lord, my humble submission is that
Putting the
my lord,
same
they are
thing.
somehow trying to show me above 35. They are themselves confused. Their initial medical board says 32 to 38.
No.
Thereafter,
No, never.
my lord,
Let him show.
35 to 40.
my lord,
35 to 40, age assessment board.
I'm showing, my lord. Kindly see.
He is now trying to confuse.
My lord, I mean, page
Yes.
11, my lord, of the report. It clearly shows, my lord, Gautam Hori in such and such has been examined for initial.
Oh.
Periodical
ভুল বোঝাবেন
medical
কেন?
examination. He appears to be 33 to 38
Appears
years of age. They themselves are saying, how can the report submitted by them? They are denying their own report.
Please turn to the next page. What is this? What is written?
So then this is wrong.
Oh, he appears to be 33 years. And thereafter, what is the assessment of age? Kindly see that. Oh, Baba, 11 number ta
Submission made on behalf of both the
I
parties.
am here age assessment board alada duto. You have to understand the medical terminology.
Yes, sir.
He doesn't understand the medical terminology.
Okay,
How
Matt
can I
number
make him understand?
What is the Matt?
Yes, our intention is not to create a chain of employment. Chain of employment cannot be created.
2020. And 1 or 23. Act 2024. had submission made on behalf of both the parties. আজকে হচ্ছে 24 তারিখ 2nd April for orders.
Grateful to Lord.
Grateful, Maharaj.
Animesh Babu. Yes. Second for orders. এগুলো তুলে রাখুন না।
I don't have any.
Yes.
And for the responsible.
In this matter, my lord, my learned senior friend was willing to submit a few judgments, I believe, on last occasion. Our case principally in this writ petition is that this BSF, he's a BSF employee, my lord. He was dismissed from service by invoking powers under Rule 22 of BSF rules. Our principal case here was that before issuance of an order under Section 177 read with Rule 22, my lord, reasons have to be supplied as to why his retention in the force is impracticable or inexpedient.
No
So-
subject is
Satisfaction,
satisfaction.
yes.
Rule 22 cannot be invoked. SSFC proceeding ought to have been initiated and procedural irregularity.
Yes.
Non-application of mind. All right.
These were recorded, my lord.
Enclosure not received.
Yes.
In the last occasion, my lord, your lordship direct me to collect some judgment regarding
AO pages 17 and 18 you have relied upon in the opposition. Page 17 and 18 of the opposition. What is it? Yes.
My reply also, my lord, should kindly come to page 5, my lord, that is E, and also onwards, my lord, that is the reply, all the things, my lord. বলেছি তো। That is para 3, my lord.
Para 3 of?
Para 3 of reply, my lord.
Reply of the opposition.
Yes, my lord. Reply of the opposition, my lord.
Reply of the opposition.
Yes, my lord.
Petitioner's reply, para 3.
Starts from page 2, my lord, of the reply. Paragraph 3 starts from.
Yes. Page 3.
Page 5, my lord. Page 5,
Yes.
para 3E, my lord.
Uh-huh.
Yes, my lord. That in the meantime, I was verbally informed that a staff court inquiry hearing, after referred to as SUCI, was to be held. And on around September 2022, while I was on leave, called upon on my phone, was asked to attend the office of the respondent concerned, while I was stood in front of a laptop and was asked to state that as I was being directed by officers concerned. Nothing thereafter on before that was ever intimated to me, nor was provided with any documents of the SOCI so that I could properly, lawfully exercise my statutory rights of cross-examination, or any other recommendation of the SOCI was never communicated to me. Finally, after receiving show cause notice dated ato, I for the first time informed that the said inquiry has also found and established that you have been involved in illegal gratification. Next, my lord, that after being issued with show cause notice dated ato, after receiving the reply show cause on 20th October 2023, the commandant ato this SMBSF without shall provide reply of the said contention, paragraph and save as.
No, you've missed one page.
Yes. Next page, my lord. Page 7, my lord. From record, save with the specifically
You were
admitted.
reading page 5 and then you went to page 7.
সিক্সটা কোথায়? Reply তো ওরা দেবে। 6 page টা
No, my lord, there appears to be a problem. My lord's copy has page 6, my lord, I believe.
Yes.
In the photocopies, my lord, it is missing. I just found it this morning. Page 6 is missing.
That is your problem. That is not my
Apologies for that.
problem.
Page 6 means yes, my lord. You should like rightly identify, my lord. That page 6 আছে তোমার
না,
কাছে?
দেখছি না এখানে।
All right, what is the decisions you
Decision, my lord. This is the decision, my lord. They are referring this, that is, my lord, judgment reserve, that is their Satyapal Singh versus Union of India. And another unreported judgment, I think, SCC online, Sriram versus Union of India. Firstly, my lord, that Satyapal seeing ex-head constable versus Union of India. This is not similar matter, my lord. This is totally separate matter. Your lordship, kindly come to, my lord, the conclusion part, my lord. That is page, my lord, 307 নাকি এটা? এটা কত পেজ? হ্যাঁ? Para 8. Para 8, my lord, of the order, my lord.
Yes.
We may also notice that in section 62 of the Act, page 15 and 20 of
Yes,
20.
yes.
Conduct of the inquiry when any person subject to act has been absent from duty without authority for a period more than 30 days. The report thus would be foundation for the competent authorities to decide whether to take a disciplinary or administrative action consonant with the provisions of the Act. In the present case, the authorities have opted to take administrative action as postulated Rule 22 of the rule required petitioner to be dismissed from service. The administrative action in terms of rule exception to regular trial of the security force and proper application of mind requisite satisfaction would be conditioned precedent invoke such provision, my lord. This is a separate because, my lord, this is under, my lord, Force Act, my lord. But this case, my lord, interrelated to, my lord, Civil Act also, my lord. তাই তো? Illegal gratification as well as Civil Act. This is a absent, my lord. This is a totally, my lord, allegation is, my lord, unauthorized absent, my lord. But this case, my lord, contains to, my lord, illegal gratification as well as criminal retrospective, my lord. And then, my lord, you know, she kindly come to, my lord, another case, my lord. এটাতে কি আছে? একই। This is not so applicable. Border Security Force Act, but this is allegation is, my lord, totally different, my lord. Then judgment. If you kindly if you kindly see the Constitution Bench order, my lord, that is Union of India and another versus Tulsiram Patel and others. Various reported, my lord, AIR and also, my lord.
Yes.
The famous judgment, my lord. You should kindly come to, my lord, head note, my lord. That page 2, my lord, bottom portion, my lord. Head note, my lord. Article 311 of the Constitution confers certain safeguards upon the person employed in civil capacities under the Union of India or state. The first safeguard, which is given by the clause 1 of Article 311, is that such person cannot be dismissed or removed by an authority subordinate to that by which he was appointed. The second safeguard, that is, my lord, article.
How is this applicable in this case?
311 2B, my lord. As far as this dismissal is concerned, my lord. Because, my lord, this is the exceptional case, my lord. And then 133 Article 300 is that cannot be dismissed, removed, or reduced in rank except after an inquiry in which he has been informed of the charge against him and given a reasonable opportunity of being heard in respect of those charges. That is applicable this because it was heard by the, my lord, petitioner, my lord. Reasonable opportunity of hearing is there, my lord. 311B also applicable this because 2B, my lord, because that dismissal came into consideration under article this 311 2B. A reason order has been also passed by the disciplinary authority, my lord. এটা একটা রুলসটা কোথায়? ও আচ্ছা You should kindly come to then next, my lord, head note, my lord. This is quite similar for this case, my lord. Then, my lord, you should kindly come to that paragraph, my lord. Reduced rank 138 Article 311 that he cannot be dismissed, removed, or reduced a rank after an inquiry in which he has been informed of the charges against him, given a reasonable opportunity of being heard in respect of those charges. The second safeguard is that, however, not available when a person is dismissed, removed, or reduced in rank in any of these cases out of clause A to C mentioned to the second proviso to Article 311(2). Under clause A, such a person cannot be dismissed, removed, reduced in rank without any inquiry or ground conduct which has been led to his conviction on a criminal charges. Under clause B, any of the three penalties can be imposed where the authority empowered to impose any of the penalties is satisfied that for some reason to be recorded by that authority is in writing. It is not reasonably practicable to hold such inquiry. Under clause 3C of any of the aforesaid penalties can be imposed where the president or the governor, this is the, all the government submit in the above appeals, deed petition had been either dismissed or removed from the service without any holding any inquiry. That is not applicable, this, my lord. So, my lord, 311 2B, my lord, totally, my lord, involved in this case, my lord. This judgment is covered regarding this case, my lord. This is my humble submission. This interpretation also there, my lord, several interpretation. Your lordship kindly come to, my lord, page 89 and others page, my lord. If your lordship see that, the inquiry, my lord, that is Article 311 interpretation is there, my lord. So, my lord, this is my humble submission.
Yes, what would
My
you
lord,
like
may I
to
briefly
submit
respond to
reply?
this, my lord?
Yes.
My lord, he has, my learned senior friend has referred to Article 311, my lord. My lord is aware that under 311 2B as well as Fundamental Rules 56, my lord, a person can be compulsorily retired. I am trying to draw an analogy here, my lord.
What is the punishment that has been imposed upon you?
I have been dismissed, my lord.
All right. Yes.
My lord, I'm trying to draw an analogy. Kindly indulge me for a moment, my lord. But here, my lord, I'm referring to one judgment, my lord, Baldev Raj Chadda versus Union of India, 1984 SCC 321.
In reply, you are showing a judgment.
Only one para, my lord. Only one para. My lord, the only thing that I'm trying to state here is that here the authority has merely stated that based on the reports, we have decided that it is impracticable and inexpedient to keep you in the force. And we are doing it in public interest or whatever the reason might be. I am trying to maintain the security, safety of the nation, etc. And it kindly comes to paragraph 8 of this judgment. May I please?
Yes, yes.
This takes us to the meat of the matter, whether the appellant was retired because and only because it was necessary in the public interest to do so. It is an affirmative action, not a negative disposition, a positive conclusion, not a neutral attitude. It is a terminal step to justify which the onus is on the administration, not a matter where the victim must make out the contrary. Security of tenure is the condition of efficiency of service. The administration, to be competent, must have servants who are not plagued by uncertainty about tomorrow. At the age of, my lord, kindly skips a few lines, my lord. And if my lord kindly sees, so it is that we must emphatically state that under the guise of public interest, if unlimited discretion is regarded acceptable for making an order of premature retirement, it will be the surest menace to public interest and must fail for unreasonableness, arbitrariness, and disguised dismissal. To constitutionalize this rule, we must so read it as to free it from potential for the mischief we have just projected. The exercise of power must be bona fide and promote public interest. You know, I am trying to impress upon your lordship, my lord, that this arbitrary dismissal without any finding as regards impracticability and inexpediency to retain me in the force, my lord, this I'm trying to draw an analogy here. Because even in case of premature retirement, my lord, it is said that the central government has unlimited discretion. However, my lord, certain restrictions are so implicit that they may not be spelled out even in a constitutional order. My lord, nobody can just pick up somebody and dismiss him only because he feels that it is impracticable, especially when no reasons have been supplied. Also, it is a case that the reports of staff inquiry, my lord, have not been supplied to me. And my learned senior, when he last appeared in the matter, my lord, he even took your lordship to that page where he has signed the receipt of the show cause. But it was his specific case that the show cause was received, but the enclosures were not there. But this is my specific case.
There is nothing on record that you wrote to the authorities that the show cause is there, but the enclosure is not there.
That is, my lord, but the tenor of the reply to the show cause, my lord,
come to page 34,
my lord, may I? I have consistently stated and I have consistently referred to the show cause. My lord, this is in aid of my submission that the enclosures were not received.
Page 34, my lord. Can you come to, my lord? It is quite different story, my lord. Timely now.
Page 34, teacher, sir.
7. Page 34, opposition.
Page 34.
Page 34, para 7. Yes, my lord.
What is there?
Page 34, page bottom portion, my lord, in view of the facts brought SUCI, additional SUCI proceeding, considering the case in its entirely entity, I therefore direct that service of
1 minute. Page 34.
It's not paginated, my lord.
Lastly, my lord, it was paginated. My last
Page
topic.
34 in view of facts. Now your
Yes, ma'am.
pagination is not tallying with this pagination.
Page R2, my lord. R2, my lord.
Yes, 29 June's order.
Yes, my lord. Yes,
5 out of 6. Page number 5 out of 6. Yes, in view of the facts, you place that.
Page 7. 7 panel. Paragraph 7. 7-1. Service of register number ato Faraz Zaman, that is petitioner herein, BSF Brigade, Kajol Mondol, register number ato, Jewel, then STC, be terminated under Rule 22 of the BSF rules for the reason mentioned in proceeding, para as further disciplinary action is inexpedient due to involve of civilians as well as ongoing CBI investigation.
Are you aware of what is the fate of the CBI investigation?
That is pending, my lord, as
Still
per my
pending.
instruction, my lord. That is pending, my lord, still.
All right. Please come. Hard submission made on behalf of both the parties. Fix for orders on 9th of April.
I'm grateful, man.
Yes, next.
I appear for the Union of India. There is a small correction is needed in the cost title, my lord.
In the cost title?
Yes, my lord. Instead of Department of Pharmaceuticals, it should be Department of Fertilizers.
Cost title of the writ petition.
Yes, my lord. That is the instruction I have received, my lord.
Which Department of Pharmaceuticals will not be there?
No.
It will not be there. What will be there?
Department of Fertilizers.
Fertilizers. Petitioner, you have to take care of it.
Kindly grants me leave, I shall correct it here and now.
Ministry of Chemicals and Fertilizers is there, but it will be Department of Fertilizers. All right.
Lordship, kindly have a look of your Lordship's order dated 10th March.
Let him place his case. Or has he finished his argument?
No. This Lord, it will be.
No, I have not finished my argument. I have not even opened my argument.
Lordship has passed
But
the
there is
order.
that is a prima facie order. I will invite your lordship to kindly, revisit the entire issue. I am not asking your lordship.
Employer to revert with written instruction in the matter. Employer was directed to revert with a written instruction.
Yes,
That is at that stage.
Only for the purpose of proceeding with the idea that the employer does not feel. Oh, whether you could engage somebody else.
Yes.
Have you?
I have taken instructions, my lord. They are ready to, my lord, change the inquiring authority.
All right.
I am not ready to face.
I have also.
You are not ready to face the trial.
There is a reason.
Yes. Give me the name of the inquiry
Yes,
officer.
Lord. One Mr. Partho Chatterjee, Lord, ex-Vice President, HR of Balwari Company Limited, a Government of India undertakings.
All right. I can see that the petitioner alleged bias against the inquiry officer and requested a change. Now the authority has accepted your proposal.
No, apart from that, the charge sheet is under challenge.
Second time changed.
This is the second time change.
All right. Yes, please.
In the writ petition, please see the phrase. The pages 54 or it is also at 28 and page 34 is under challenge.
Yes.
Page 54 is the charge sheet.
All right, let the proceeding continue. We'll see what's going to happen.
Kindly, the proceeding cannot continue. With greatest of respect, kindly hears me for 5 minutes. Thereafter,
let the opposition be filed.
Your lordship will kindly hear me for 5 minutes. Your lordship will kindly hear me for 5 minutes. If your lordship feels that I don't have a case,
This is not the document, Lord. This is the another document. This is
the document.
Kindly,
Partho Chatterjee.
Yes.
Kindly allows me to place the case, just for 2 minutes, not even 5.
You are challenging the disciplinary proceeding.
The charge sheet. Kindly see the charge sheet. Kindly see the charge sheet once. I stop. Please see page 55, 56. It is alleged had submitted a handwritten job application, published apropos an advertisement. I am just shortening it, where he has disclosed his date of birth to be 14/1/69 and has not written the age in words, 45 years and something. Now, first of all, this cannot be a charge because, my application is at page 64. In that, here I have categorically mentioned 14/1/69. That is my date of birth. And here it is 45 years. After disclosure of this and after disclosure of all my credentials, if today they have found me suitable to be selected, after 11 years, they cannot saddle me with a responsibility. That too on the basis of a complaint lodged by an INTUC leader. That is number one. Number two is, they have alleged that my qualification BSc. That is also disclosed. All my certificates, credentials, everything produced at that stage at the time of my initial selection. Today, to call upon me to say that why I have done this and why I have not done that, they have thereafter on 2 occasions promoted me. And this same gentleman who has issued this charge sheet, he was a part of the selection committee. If I have not fulfilled all the requisite qualifications earmarked for the post, they would not have selected me. Now, I am covered by MS Mudhol's judgment. I am citing for your lordship. Kindly
it may be that the inquiry officer may go into it and say everything is bad.
There is a reason. My learned friend today is appearing for the corporation. He has been, I tell you, lordship, I was there, as a presenting officer for a person, where my learned friend was representing the matter traveled to the Supreme Court. One of the persons here who was named inquiry officer, there also, there was an issue. This is a clear case of bias, just 7 months prior to my retirement. I am going to demit office in the 58 is the age of retirement here. I am going to demit office, in the month of January 2027. It's only 7 months left. They only want to harass me because, why? Kindly looks into the nature of allegations. One of the allegation is, some LinkedIn profile, they have not given any other detail. I do not know whether who has uploaded it.
To say all these things before the inquiry officer.
It is true that at the threshold I was not there. Kindly permits me to say this to your lordship. If the charges have no legs to stand on, if the charges do not constitute a misconduct, charges have to constitute misconduct, as we have learned from your lordship. This is not a case of negligence. This is a case of where I disclose all my cards. They select me after 11 years, after putting in and after 2 promotions granted to me. I have filed a supplementary affidavit. It is already on record. Kindly sees page 23. Kindly sees one of the other pages. It is clearly indicated that the entire gamut of the problem, these persons found me suitable, found me eligible, found me suitable not only for the higher post. If today, I am going to face an inquiry, I am the DGM there, and I've been promoted from the rank of a manager to the rank of DGM. Today, I am going to face, this biased inquiry just because, I could not.
The court will be here to see. They will not conclude the proceeding. No final order will be passed without the leave of the court. And I'll fix up a time limit within which it is to be completed so that you still have time prior to your superannuation to challenge it. Because
of course, is your lordship's prerogative.
For the going into all these things, the respondents have to be given a chance to file their affidavit.
If your lordship feels, if today, let us assume, with all humility, someone is appointed in a post in 2014, and he is selected in that post after disclosure of all his cards, and thereafter, on the basis of that disclosure, he is subsequently promoted 2 tiers up. Can that person be suddenly called upon to explain as to why he has not written 45 years? If the earmark was 45 years, and if he has been called for interview, and if he has been ultimately selected, despite him disclosing in the very same page that his date of birth was 14/1/1969, I put this question to myself, where is the misconduct here? I put this question to myself, where is the charge?
That will be decided. Only one submission I have.
Kindly permits me to cite this judgment before your lordship. Kindly take this on
Petitioner
record.
is aggrieved by the steps taken by the authority to initiate disciplinary proceeding against him. Stop. The primary allegation of the petitioner is that the charges so framed against him cannot be permitted to be continued in a disciplinary proceeding. Stop. The petitioner had disclosed all the documents relied upon by him at the time of his appointment nearly 11 years back. Stop. Relying upon those documents, the authority permitted the petitioner 2 promotions, and at the very fag end of his service career, the authority has initiated the disciplinary proceeding. Stop. The petitioner alleges bias against the employer. Stop. Paragraph.
Not employer, Lord, the inquiring authority.
Against the employer. Against the disciplinary authority.
Not a single
disciplinary authority is a part of the TPC.
Yes. I followed it. It's against the employer. Next, the to rule out the allegation of bias against the inquiry officer, the court video order dated 10th of March 2026 directed the employer to propose the name of a separate inquiry officer for conducting inquiry in the matter. Stop. The employer has come up with the name of a different inquiry officer. Stop. But since the petitioner is not at all willing to face the inquiry, accordingly, the instant writ petition is required to be decided. Stop. The respondents are directed to file affidavit in opposition within a period of 4 weeks. Reply, if any, within a fortnight thereafter. No interim order.
Kindly, in that event, if they are fixing an inquiry, then,
yes.
If your lordship feels that the charges have to be gone into, then, wholly without prejudice, I have to participate. That is one aspect of the matter. Because, today, if I participate, If I participate, the point regarding the charge sheet, that it has no basis, the charge is absolutely not only, it has no legs to stand on.
Yes. This the court will decide after.
But in the meantime, kindly protect me.
What type of protection?
Protection is the inquiry cannot be proceeded without leave of court.
At the first stage. Just after.
Without leave of kindly record that your lordship is rejecting this.
Premature.
You can,
and I would be at liberty to
open for the petitioner to participate in the inquiry proceeding. Stop. It is, however, mentioned that final order of the proceeding will not be passed without the leave of the court.
No, that is Lord, I have some objection on that.
Not be passed. The writ petition is pending.
Lord, this writ petition will not be heard, Lord.
Lord, kindly granted to the advocate on record of the petitioner to amend the description of the respondent number 1 in the cause title of the writ petition.
Lord, only one submission I have, Lord, at the very initial stage, Lord, they have challenged the charge sheet. Lord, this writ petition is premature one. Lord, he did not want to proceed.
The disciplinary authority whom he is representing
yes,
in my promotion.
Yes.
How could he promote me?
I can.
Disciplinary
I can handle you as a counsel for both the
preliminary stage.
There is no bar.
The court ought not to restrain the authority from proceeding with the disciplinary proceeding at this stage.
Great.
Next.
But may I have the copy of this document, Milord? The name of the.
You must be having a copy with
No,
you.
I have not no copy.
Take it
Milord, I will give Xerox it and I will hand over to Milord.
Next.
My lord, 10 what happened, my lord, relating to appointment of police, my lord, there was a certain direction. The direction they have complied with. Direction was duly complied. They have made available each and everything, my lord, in their website. But while, my lord, checking and examining all those, my lord, it's a complete mess. One example, my lord.
That will be a fresh cause of
No,
action.
no, my lord. My lord, I intend to, my lord, multiplicity of suits and proceedings. Today, my predicament is my advocate on record, little girl, my lord, severely burnt and, my lord, admitted in a hospital. Not even the brief is with me. I am seeking 10-15 days time, my lord. Meanwhile, my lord, I will come with the appropriate application before this, my lord, court. After that, my lord, if this honorable court decides, my lord, I will go out of this court with the liberty to come afresh. Today, my lord, because of my advocate on record, my lord, he is in the hospital, my lord, along with her little daughter.
1 minute. What has been complied with?
There was direction, my lord, to disclose the each and every details, cut-off marks.
Right. So after the details are disclosed, you have got to.
No, my lord. My lord,
know that there
just
are
I have prepared my lord the appropriate application. As it seems, my lord, there are, my lord, the number of posts, my lord, the mean for the different categories. My lord, in supposing, my lord, you are.
No, I understand.
Yes.
After the disclosure is made in the website, you discover certain illegalities.
Absolute illegality.
Challenge it.
No, my lord, if it is possible, my lord, by filing an appropriate application, if this honorable lord, otherwise multiplicity of suits and proceedings, my lord, they are the unemployed youth.
What
They,
was
my lord,
issue?
my lord, they are the unemployed youth. They are before this honorable court after paying court fees, my lord. My lord, tomorrow, my lord, they have to come back once again and, my lord,
Shortlisted candidates
to initiate, my lord, the fresh proceedings.
Your proceeding, your further prayer cannot fit in the prayer already here.
Even then, my lord, I am not, my lord, prevented to file one amendment application. Allow me, my lord, 10-15 days time in the name of my advocate on record.
It has been submitted by the learned advocate representing both the parties that the direction passed by the court on 10th March 2020.
That is interim direction, my lord.
Directing publishing of the details of the candidates who appeared in the examination has been complied with. Learned advocate for the petitioner submits that upon such publication of the details, certain illegalities have come to the notice of the petitioners. The petitioners intend to file a supplementary affidavit. Will it be a supplement or an application?
Amendment application, whatever, my lord, we have prepared it. My lord, the only difficulty, my advocate on record.
A further application for consideration of the court. Prayer has been made to adjourn the matter for the time being.
My lord, kindly record my advocate on record predicament, my lord, because of that reason.
Regarding the submission, regarding illegalities, that is, we are objecting it.
Let the application come. There is nothing to record.
Yes, submission that.
If he comes with an application, you'll certainly have a chance to oppose it.
Deeply obliged.
If he makes a submission, that is not sacrosanct.
Right.
Deeply obliged.
Right. Acha. Hearing of the writ petition stands adjourned till 21st of April.
21st of April. Deeply obliged. Deeply.
They are filing application on
I
April.
do not know. There is no observation of the court. It is his submission that has been recorded. The court has not passed any order giving him leave or permitting amendment, nothing of the sort. Yes, 10. Oh, 13. 10, 13. Yes.
Article number 13, I am appearing. Madam, petitioner is the.
This is your other side.
Other side, I have people on the last Friday.
I'm for the same.
State.
Madam,
What is
petitioner is the dismissed assistant sub-inspector of police, dismissed for a charge for contracting a second marriage. His personal law
permits it.
Permits. Madam, that is the one point is the petitioner was posted in a police stations.
Show me the order of dismissal.
Yes, yes. Order of dismissal 69, my lord. 69. Actually start from 70, my lord. 70.
Yes, final order.
Should I read, my lord?
Where is the operative portion of this order?
Yes, my lord.
Page 71.
My lord, operating per 71. I am reading from para 5, my lord. Bottom, at the bottom. On 4/9/25, the charge officer was directed to appear before me on 8 September for personal hearing and to collect the copy of findings. The charge officer collected the copy of findings and appeared on 8th. During personal hearing, he stated that he had nothing to say. A so-cause notice was issued to him on 9/9 with a direction to reply within 7 days as to why a major punishment should not be awarded to him. He received in on 10th. On 13th, he paid for 21 days more time. Out of 7 days extension time was allowed. Now, next page, para 6. The charge officer submitted his reply on 23rd to the so-cause notice, wherein he raised finger to the inquiry report and contended that the charge drawn up against him under Rule 5(4) of the West Bengal Service Duties, Rights and
This is the order. This is the final order of the disciplinary authority.
Yes, yes.
Where is your appeal before the appellate authority?
Yes, madam. My appeal was not yet disposed of, my lord. I have preferred the appeal.
Where is the appeal?
Appeal is, my lord, in my CAN application, my lord. CAN application.
Who is the appellate authority?
Appellate authority is the Deputy Inspector General of Police, Barasat.
Where is the first page of your appeal?
My lord, it is at page 10. 8, my lord. Sorry, 8. Actually, Inspector General of Police is in charge of the Deputy range, Barasat range, my lord. He is now there.
The IG.
IG.
25th of February, this has not been disposed of.
Yes, my lord.
It has not been disposed
No,
of.
no. I have paid for this, my lord.
30th March is the date for their appearance.
Yes, yes, my lord. They have called me for personal submissions before the appellate authority.
Go before the appeal.
My lord, my humble submission is the entire proceeding has been drawn on wrong footing.
Yes, you go and tell this before the appellate authority. Please come. The petitioner was serving in the West Bengal Police.
Yes, my lord.
Force. Stop. A disciplinary proceeding was initiated against him and he has been dismissed from service. Stop. challenging the order of the disciplinary authority, the petitioner has preferred an appeal before the appellate authority, being the Inspector General of Police, Presidency Range, Barasat, on 25th February 2026. Stop. The said appeal is pending consideration till date. Stop. It has been informed by the learned advocate representing both the parties that 30th 30th of April.
March.
Oh,
Next-
March.
Next Monday, my lord.
Is the date fixed by the appellate authority for hearing the petitioner. Stop. Paragraph. As it appears that the order impugned in the writ petition, being the order of the disciplinary authority, is an appealable one, and an appeal has been preferred before the competent authority, which is pending disposal, accordingly the instant writ petition stands disposed of by directing the appellate authority to consider and dispose of the appeal preferred by the petitioner in accordance with law at the earliest. Stop. A reasoned order shall be passed and communicated to the petitioner. It is made clear that this court has not entered into the merits of the claim of the petitioner, and all points are left open to be decided by the appellate authority in terms of the appeal preferred by the petitioner. Application and can both disposed.
I have submissions. I have prayed for defense assistant before the appellate authority. A separate prayer is it. Kindly direct the appellate authority, kindly allow me.
And is it permissible in your service rules?
It is according to regulation. It is
It's your submission.
No, not after 20 years.
The prayer of the petitioner for engagement of a defense assistant has also been made before the authority. Stop. The authority shall take a decision on the same in accordance with law.
Grateful.
Next.
Nice.
On the mandate, item number 148.
For the state response.
Lordship, I am for the petitioner, Lordship.
I'm for
As for the last document, the state should file a report, Lordship.
Not filed?
Not yet, sir.
Directed the file manager to report. I'm over telephone matter, I'm instructed by the department matter. On matter 10 days time to be 10 matter for file.
Last occasion also you sought extension of time.
Yes, Lordship.
Now also you are seeking extension of time. Aligunto, on the prayer made on behalf of the state, seeking extension of time for filing the report, time is extended.
Lordship, kindly short time should be given.
Till
Last occasion 1 month, they are.
till 10th April 2026.
Suffering from long time.
Stop. A copy of the report shall be circulated in advance to the learned advocate for the petitioners. Stop. Release the matter for consideration on 4th May 2026. Stop. It will be open for the petitioner to file exception to the report prior to the adjourned date. Next.
Item number 149.
Dismissed. Can dismissed.
My lord, I am for the petitioner.
I'm here for the Union of India. Led by Mr. Bhujes. My senior has not come today because his mother is critically unwell. She is suffering from cancer. List the matter for next week. List the matter next week.
Next week?
Next week.
What is the matter about?
My lord, may I make it clear? My lord, here the petitioner is a serving nursing officer of Indian Army. And now there was some policy she joined in the nursing in 2000. There was some policy which came in 2017 16, which says that those who joined prior to 2015 shall not be given permanent commission. CH and these nursing officer, even though they are short service commissioned officer, they did not get the permanent commission. And after serving 17 or 18 years, they were not eligible for the ESM benefits. Now the matter was taken up before the Apex Court. They are getting the benefits of the ESM now. So the matter is, petition is settled now.
You do not want to proceed?
I do not want to proceed because
All right, learned advocate for the petitioner submits upon instruction that the petitioner is no longer inclined to proceed with the writ petition, as a decision has already been taken by the Union of India.
My lord, second paragraph. And I'll read.
Stop. The notification dated 9th February 2026, published by the Ministry of Personnel, Public Grievances and Pensions, bracket open, Department of Personnel and Training, has been relied upon. Stop. In view of such submission, the writ petition stands dismissed as not pressed. This will be retained with the records.
My lord, and the petitioner is entitled for the ESM benefits that can be.
I am not recording because you are withdrawing your petition. All right.
Dispensed.
Next.
Published.
151, Lord, I'm appearing for the petitioner in this matter. Brief to the week.
Your other side?
My lord, if it is not placed as disposed, it will be good. I'm praying not placed.
You are not proceeding, so it is dismissed as not pressed. You are not proceeding, that you say because of the
in the light of the Honorable Apex Court order.
Yes.
I'm infructuous now. But
all right.
He was praying that all.
What you are praying is not important. Now the Apex Court order is there, so everything is covered. What remains in the writ? How does it matter?
Only thing is that if it is dismissed, it gives only a wrong.
As not pressed, it is not dismissed on merits. There is a difference. All right.
My lord, railway are the authorities. My lord, must be the union must come in, my lord.
I can see the Council of the Union was present on the last occasion.
Yes, they were present.
Then?
My lord, only one thing, my lord, I would just indicate, my lord, there is another writ petition filed previous to this, where this honorable court found prima facie case of mine. What happened, my lord? That I am a direct recruit under sub-inspector under the railway authorities. Now, my lord, I took a transfer, my lord, from the railway special force to the Eastern Metro Railways. So, my lord, on this transfer, my lord, an issue cropped up, my lord, my seniority was not considered. Now, my lord, a list was published. I challenged that list, saying that as per the rules of 1987 and the amended rules, the seniority will remain the same. There will be no change. So, my lord, this was not considered by them, and they published a list. Now, in the meantime, what happened? For a departmental promotion, my lord, an examination was called for from sub-inspector to inspector. Now, my lord, 60 candidates were sought to be, my lord, filled up, my lord, for vacancy of 49. So, my lord, as per the seniority list which was published, my lord, I was below that since they were not considered.
Is there a common gradation or seniority list? No.
Yes, my lord, common. My lord, those who are promoted, those who are directed, they follow in the common, my lord, gradation list of seniority.
Yes.
Now, my lord, my seniority, my lord, will be at par with those who have been promoted.
That has not been given.
That has not been given effect. That was challenged in the previous writ petition. So, my lord, what happened in the meantime? They took out, my lord, for promotion the examination date of examination to inspector rank. Now, my lord, I did not qualify because my seniority fell down as per them. My lord, I challenged it. Court said you very well participated as an interim order. You participated in the examination. I qualified in the examination. I succeeded in the examination. Now, my lord, again, my lord, as my seniority is below, my lord, persons who have been appointed much below to me later, my lord, they have been promoted to inspector. Now, my lord, this is the second. So, my lord, these two writ petitions need to be tagged together.
That one is pending.
That one is pending. And in the meantime, this has happened. My lord, WPA 29040 of 2024.
Let this writ petition appear along with on 6th April. Stop. Let notice be served upon the learned advocate representing the instant writ petition, representing the respondents. Ki bolna?
Counsel, my lord, let be counsel.
Right, in the instant writ petition and the other writ petition. Counsel.
Because the advocate represented in the earlier writ petition, same counsel would appear for the union and the railways.
Not necessarily.
আলাদা আছে?
Not necessarily. They may differ. So please give notice to whoever is there so that it can be taken up. Yes, my lord, I am for the petitioner. His affidavit of service. The prayer for pension. Are you there
Madam, I am for the PF.
for the?
Provident Fund Authority. Provident Fund Authority.
What about the Union of India?
Also Union of India, my lord, I am also.
Provident Fund.
I am appearing on the PF Authority.
PF authority. All right, let me hear. And not the company. Burn standard, you are not appearing.
No, no.
All right, what is your grievance?
My lord, the grievance is, my lord, the petitioner was a permanent employee of Bound Standard Company since 1986, and he was about to retire on 2021. But in the meantime, in 2018, voluntary retirement scheme was offered to the petitioner. And at that time, the petitioner's wife also got very critical because of her battle with cancer. He was retired from the post of maintenance from the main department on 10th September 2018. And after that, my lord, petitioner's wife was died on 14th May 2019. And at that time, he could not pursue with the matter of his pension, my lord, because he was having 2 children. His wife was died. But from 2023, petitioner's funds has started to pursue for the pension of the petitioner. The representation was also made, my lord, on 12th
August 2024.
It is not start.
Where is the proof of service of this letter? Page 15.
The track report.
Where is the track
Page
report?
number last postal receipt and track report, page number 18, 19, 20.
For which?
But are you entitled to pension?
Yes, my lord.
How?
The other staffs were who was worked with the petitioner, they are getting the pension, my lord. And when he was
Is there a pension scheme in the company?
yes, my lord. It is Government of India undertaking. Bound Standard
Maybe.
Company.
My lord, he is
But
under
then
and covered under the scheme.
pension
The
scheme.
authority contacted with the petitioner. I personally called her,
Yes,
my learned friend, to contact with the concerned authority, my lord. They are willing to disburse the amount subject to the fulfillment other criteria, my lord.
Yes.
With all documents, they are directed to
Why don't
appear,
you?
my lord. They are not contacting since 2-3 months, my lord. Or before 2 months, I contacted my learned friend to contacted with the concerned authority, my lord. But learned friend, either the advocate or the authority,
Then why are you not?
petitioner is not contacting, my lord.
Petitioner's daughter was pregnant and he was.
That is your problem. You want pension. The authority is willing to proceed with your application and you are not contacting. Please come.
I will.
The petitioner superannuated from service. Superannuated. Petitioner took voluntary retirement from service on 10th of September 2018. Stop. The from service बोलना तो service of Burn Standard Company Limited on 10th September 2018. Stop. He seeks pension. Stop. Application of the petitioner seeking pension is alleged to be kept pending before the additional Central Provident Fund Commissioner. Stop. Learned advocate representing the Provident Fund Authority submits upon instruction that the department contacted with the petitioner for production of necessary documents for the purpose of processing his claim for pension. Stop. The petitioner has not responded. Stop. Paragraph. Upon hearing the submission made on behalf of both the parties and upon perusal of the materials on record, it appears that that there is no formal communication from the end of the respondent authority with regard to the formalities that the petitioner is required to comply for getting pension. Stop. Paragraph. The instant writ petition accordingly stands disposed of by directing the who will be the authority? The Regional Provident Fund Commissioner. Regional Provident Fund
Respondent number
3. Respondent number 3 is Regional Provident Fund Officer is directed to take necessary steps to intimate the petitioner the formalities that he is required to comply for the purpose of release of his pension. Stop. Steps shall be taken in the matter
Sir,
of the
direction will give it to appear personally before the authority, my lord.
Yes, my lord.
They will consider.
You intimate
My lord.
an opportunity of hearing may be provided to the petitioner for production of documents if necessary.
My lord.
Yes, stop. Decision shall be taken positively by 12 weeks from the date of communication of this order. Disposed service taken on. Grateful, madam.
I'm representing Mr. Anil Kumar Gupta, who is representing RPFC.
Where is Mr. Gupta?
So, ma'am, he's actually out of station. So he is I'm praying for the adjournment for 2 weeks actually.
I cannot hear you.
Praying for the 2 weeks adjournment, ma'am.
2 weeks adjournment. What is the matter about?
My lord, petitioner prays, my lord, before your lordships to release the, my lord, retirement benefits and pension. My lord, on the earlier occasion, petitioner came before this honorable court. My lord, kindly see the order page at 79.
After this, was any communication made to you by
Yes,
the
my lord.
Provident
Yes,
Fund?
page 83. Page 83. My lord, I have deposited my contribution. Well, that is at appearing at page 83, 84.
Thereafter?
Thereafter, I made representation, page 85 onwards, my lord.
Are you aware as to whether the employer's share has also been paid?
Yes, yes, yes.
Where is it?
My lord, this is page 87, 87.
Yes. Now the money has to go to you.
My lord. Regional Provident.
Are you there in the panel?
No, ma'am.
No.
Mr. Anil Kumar Gupta is there.
But then since he is not here, his
Yes,
name
ma'am.
cannot be recorded in the order.
Okay, ma'am.
And please come. The petitioner prays for a direction upon the Regional Provident Fund Commissioner.
My lord, respondent number 5.
Kolkata. Respondent number 5.
My lord.
To release the Provident Fund dues. To release his Provident Fund dues. Stop. From the documents annexed to the writ petition, it appears that both the employer and the employee's contribution of Provident Fund has been deposited before the competent authority. Stop. The same is required to be disbursed in favor of the petitioner. The petitioner has made several representations seeking disbursal of the Provident Fund dues, but the same has not been responded to by the authority. Stop paragraph. As it appears that, admittedly, the Provident Fund dues of the petitioner have been deposited before the Provident Fund organization, accordingly, the instant writ petition stands disposed of by directing the respondent number 5 to disburse the Provident Fund dues of the petitioner at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. The petitioner shall be intimated about any formality that he is required to comply for the purpose of releasing the money in his favor. It petition disposed.
Lord, another prayer I have made, my lord, EPFO pension, my lord. My lord, that is also not considered by taking into consideration my lord, notional effect of my service. That
But
is
then
also,
that has to be decided whether you are at all eligible for
let them consider. My lord, I have made representation
Page
96
90.
last annexure. My lord. এবং আদেশ নামা 10 বছর পিএফ পাওয়ার অর্ডার পাই, এই মতো অবস্থায় আমি আজ পর্যন্ত ইপিএফও পেনশন পাইনি। ভালো কাইন্ডলি সি।
The petitioner also seeks for a direction upon the Regional Provident Fund Commissioner to consider his claim for pension. Stop. A representation dated 21st August 2024 appears to remain pending. Stop. The respondent number 5 shall also consider the petitioner's prayer for grant of pension in his favor in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. Learned advocate for the petitioner is directed to forward a copy of the representation dated 21st August 2024 along with all relevant documents to the aforesaid respondent at the time of communicating the order of the court. Disposed. A reasoned order shall be passed and communicated to the petitioner.
Well, grateful to this.
My lord, in item 154, I appear for the petitioner. I'm led by Miss Juma Sen. However, there has been a emergency, medical emergency at her house. She had to leave the court during the break time. So I was praying for not today.
Only not today?
Yes, my lord.
Who is your other side? Are you aware?
Sir, Devasis Basu is appearing on behalf of the orthotic
On behalf of the
Union of India.
Union of India?
Union of India, yes.
Yes. Where is he?
He is code number 8.
Every day he is somewhere or the other and he's not here before the court, and at the time of giving the appearance slip, his name is there.
My
I
lord,
make
on
it
the-
not today.
Grateful.
Tell him to be here tomorrow along with instruction. Next.
No, I am for the
May it
respondent.
please your lordship, my lord. Now kindly see the order dated 9th of February 2026. The lordship was pleased to pass a direction to, my lord, to sub a copy and implead the, my lord, the wife also a party respondent. We have impleaded and, my lord, this is the affidavit of service.
Anybody representing the wife?
Thank you.
No.
My lord, may I please?
1 minute.
আগের দিন অর্ডারটা
Yes.
Lord, petitioner was enrolled as a constable 3rd of May 2017. Subsequently, my lord, he went to the training, and after my lord completed his training, my lord, he has been posted.
Petitioner is a Hindu.
Yes.
All right.
And my lord, he received a complaint. My lord, the respondent received a complaint from the my lord that petitioner contracted a second marriage with a lady. So, my lord, he has been asked to furnish his my lord the representation, saying that what is the stand taken by him. So the then assistant commandant, who was his reporting officer, he told him that you narrate everything what he has been dictated by the my lord, that senior officer. He, my lord, wrote everything, put his signature over there. Then on my lord 6th of December 2025, my lord, petitioner received my lord the show cause notice appearing at my lord page, this show cause notice, my lord, at page 17. Kindly take my lord page 17.
Yes.
Whereas you were enrolled in the Border Security Force of the Constable on 3rd of May 2017 and after the completion of the basic recruitment training, STC BSF Hazaribagh posted in the 118 BN BSF 4th of July 2018. Whereas a court of inquiry has been conducted, video 18 such and such of the BSF order number such and such dated such and such, to investigate the allegation of the leveled by the Sri Kusum Kumari, wife of such and such, regarding the marriage with a lady namely such and such. So far as this, my lord, the court of inquiry is concerned, there is a specific provision that whenever the court of inquiry would be conducted, I would be notified, and my lord, in the hearing, the 173(8), my lord, the procedure would be followed, and I will make my statement over there, and I can lead the evidence also. So, my lord, behind my back, this court of inquiry has conducted. It was established through the CUI, that means the court of inquiry, which, my lord, never not been intimated. I have not been informed anything, that you had entered second marriage with such and such of such and such number such and such, and you have registered your marriage in the office registration number such and such, VD certificate number atu dated 17th of August 2024.
All right. Then you gave a reply to the show cause.
No, my lord. Kindly see, we have, my lord, placed a comprehensive representation seeking certain documents, my lord, so that I can give the reply, appearing at page 20.
Right.
Upon perusal of the notice of the reference, it appears that
What happened thereafter? Was the documents provided to you?
No document has been provided. Behind my back, I have been dismissed from service, and subsequently this letter has been, my lord, replied.
17th of July 2025 or February 2025. This has been given. All right. So you are challenging this.
My lord.
But there is an appellate authority. Why did you not go there?
My lord, the appellate authority is, my lord, since, my lord, there is a violation of the natural justice, because there is a specific violation of the court of inquiry proceeding.
All right, but you can highlight all these things before the appellate authority. More than 1 year is over. You did not prefer appeal.
No. Appeal is, my lord, 2. There is a provision of the 117 prior to confirmation of the dismissal, but this is not a, my lord, the proper dismissal. Kindly have a look at, my lord, the provision.
Well, it is proper, improper. The order you are challenging is appealable. Why will you not prefer an appeal?
Kindly have a look at, this is not an appealable. Language is different. 117. Remedy against an order, finding, or the sentence of the security force court. This is not a security force court. Marking might be there. 117, my lord, the section 117. Remedy against an order, finding, sentence of a security force court. Any person subject to this act who considers himself aggrieved by any order passed by the security force court may present a petition to the officer or the authority empowered to confirm any finding or sentence of the such security force court and confirming authority may take such steps as may be considered necessary to satisfy itself as to the correctness, legality, and the propriety of the order passed as to the regularity of the proceeding to which the order relates. Any person subject to this act who consider himself aggrieved by a finding or the sentence of a security force court which has been confirmed may present a petition to the central government, the Director General, or any prescribed officer superior to the command to one who confirmed the such finding or the sentence of the central government or Director General or the prescribed authority as the case may be, may pass such order thereon as it thinks fit and the proper. So this is, my lord, the remedy against an order or finding passed in a security force court. It has not been passed in a security force court. My lord, kindly see the order of dismissal once.
Page 23.
Page 23, my lord. My lord, may I be permitted to place?
No, Rule 7 of the BSF Rules 1969. You are disqualified to be eligible for appointment in the force.
Might be. There is no difficulty. That means, my lord, I would not be given any opportunity even.
Opportunity was given to you. You did not show cause.
No,
you did not
my lord, kindly
provide your reply to the show cause.
Kindly bear for a moment. Kindly have a look at, my lord, provision 173. Rule 173. 170, my lord, chapter 14.
Yes.
This chapter 14, my lord, when there would be a complaint to, my lord, to ascertain the, my lord, to ascertain the veracity of the complaint, a court of inquiry is being conducted. Here also the court of inquiry has been conducted. But no note, I has not been notified, nothing else. See, composition. A court of inquiry may consist of one or more members of the person subject to the act may be appointed as a member when the court is to investigate the matter of the specialized nature, when the officers subject to this act with specialized qualification are not available to such and such assembly. A court of inquiry may be assembled by the order of the commandant or any officer of the authority superior to the commandant. Assembly of the order. The order of the assembling court of the inquiry shall state the composition of the court, time and place for its assembly, and clearly state the matter which the court will investigate. It will also provide for the administrative requirement of the court. So when that, my lord, the notice would be given, time, place, and the issue of the inquiry has to be maintained. So no notice has been given to me. The court of inquiry has been conducted behind my back. Kindly see, my lord, 173.8. For, my lord, kindly have a look at, my lord, 173.8. There is a specific provision. My lord, I am referring 173.8.
Yes.
Provision of the section 89 shall apply for the procuring attendance of the witnesses before the court of inquiry. So I can produce my wife also, because the complaint which has been submitted, allegedly submitted by my wife.
Problem is, there was a show cause notice initiated, given to you, but you did not reply.
My lord, the document has not been given, so how I can reply, my lord, that has been mentioned. My lord, kindly have a look at the document once. It is not their primary obligation to, my lord, kindly see the document. Page 20, my lord. Upon perusal of the notice and that the reference, it appears that there are the two imputations against the client above named. The first imputation relates to the contracting second marriage during the subsistence of the first marriage as alleged to have been made by such and such. The second imputation pertains to false statement in answer to question number 7 at the time of the filling the enrollment form. It is purported to claim that the notice...
Nowhere in your this letter you have sought for any documents.
21, page 21.
Page 21, my lord.
Yes, read out.
It has purportedly been claimed to the notice under reference that the court of inquiry was conducted, notwithstanding making such statement, admittedly no copy of the court of inquiry proceeding was supplied to my client. It is evident that the notice under reference that no document containing the allegation of the Simuri Kusum Kumari dated such and such was provided to my client. it is also discernible from the notice that
Where is that statement? Please provide me these documents.
Miller, kindly see the penultimate paragraph, Miller.
Yes.
Therefore, the entire proceeding initiated by the purported so-called notice gets vitiated by the unfairness and the bias. You, being a statutory authority, should act fairly and affording a reasonable opportunity to my client for showing cause. For doing so, the primary document on the basis of which you have intended to keep the allegations are required to be provided to my client along with the so-called notice. In absence of those material particulars forming the basis of your imputation, it would not be feasible for my client to give reply to the purported notice under reference.
Where is this request? Please forward these documents to me. Where is that?
What more is required to be written?
It is
That
not
these
required
these
to
are
be written.
the primary document on the basis of which they are bringing home the charge. All those documents are required to be given to me.
Where is that?
This is the document, my lord. The letter of complaint I have referred. Letter of complaint of
No,
my
sir,
wife.
I read it in a different way. I do not see that you have made a request to forward these documents to you.
My lord, good bad.
Could not give a meaningful reply to the show cause.
My lord,
What is your submission? Yes.
It was established through the COI that he had entered into the second marriage with Banti Mollik, daughter of Boru Kumar Mollik, North Chobbish Pargana, West Bengal, on 17th.
Why didn't you not forward all these documents to him so that he could have given a reply?
He has not made any request for the documents, and it is his documents, my lord.
His documents mean?
My lord, it is the enrollment form. Can you see the enrollment form which he has filled up at the time of...
Already file a report. You disclose everything?
Yes,
what you've got to show. Please come. The petitioner is aggrieved by the order striking his name off from the strength of the border security force with effect from 17th February 2025. Stop. The primary ground for challenge of the order is that the court of inquiry, which was constituted to investigate against the allegations made by one, who is the complainant?
The first wife.
Banti Malik. Second, acha, Kushum Kumari. Kushum Kumari, the private respondent herein. The documents, okay. Was proceeded with without forwarding the documents relied upon by the complainant. Stop. Violation of the principle of natural justice has been alleged. Stop. It has been submitted that the authority proceeded with a predetermined mind to remove the petitioner from service. Stop. Prayer has been made to set aside the impugned order. Stop. Paragraph. None represents the private respondent. That is the first wife of the petitioner. Despite service. Stop. Affidavit of service filed in court is taken on record. Stop. Learned advocate representing the Union of India submits upon instruction that the authority relied upon all documents submitted by the petitioner at the time of entry into service.
Yes, and the nomination forms.
Stop. The nomination form signed by the petitioner was also taken into consideration by the authority. Stop. Paragraph. It has also been submitted that the petitioner did not give a reply to the show cause notice that was issued. In response to the aforesaid submission, learned advocate for the petitioner submits that in the absence of proper documents being forwarded to the petitioner, he was not in a position to provide a meaningful reply to the show cause notice. Paragraph. for adjudication of the dispute that has cropped up, comma. The Union of India is directed to file a report by way of affidavit disclosing all documents relied upon by them for passing the impugned order. Stop. The report shall state as to whether any opportunity of hearing was granted to the petitioner prior to passing the impugned order. Stop. Such affidavit shall be prepared and circulated within a period of 2 weeks. 3 weeks. List the matter on 4th May 2026. Stop.
Maybe
Yes. The petitioner will be entitled to file an exception to the report of the respondents.
Well, we need some more time.
Battalion is in
The
Kashmir.
battalion is in Kashmir.
Acha, 4 weeks, 3 weeks, make it 6 weeks. How long does it take us to meet a Havana? In that case, 8th of June. Let further notice be issued upon the non-appearing respondents who will have an opportunity to place her stand by way of an affidavit with supporting documents prior to the adjourned date. Take this document back.
8th of June. My lord, 8th of June. Great. My lord, may it be recorded that the pursuant to the previous order, we have already communicated the order.
Yes, I've recorded that she has not appeared and you have, despite service, your affidavit of service is on record. I've recorded it.
Great.
Yes.
I don't know about that.
156. Dismissed.
157, my lord, I am appearing for the petitioner, my lord. The petitioner, my lord, was working as a constable in BSF, my lord. Since December 2025, he retired. Now his grievance is at, my lord, page 36. That unlived, my lord, it has not been calculated properly, lapsed illegally, so that he has, my lord, suffered financial loss.
All right. Did you raise any objection before the authority?
Yes, that is, my lord, at page
40.
Starts from 40, my lord.
Is there a reply to the same?
No. On previous occasion, the Union of India took adjournment to file report, my lord.
Is the report ready?
My Lordship, we had sought an adjournment to seek instructions. I have a sore throat, Your Lordship. Therefore, I'm requesting my learned junior to please read out the relevant paragraph of our instructions.
My lord, in this regard, as per BSF leave.
Use the microphone so that she can also hear.
My lord, as per BSF leave rule 1971, any member of the force or enrolled person, so long as he is service in any battalion until or training unit or training institute or any border security force shall be entitled to 60 days earned leave in the calendar year, my lord. So
how many days earned leave did you calculate?
My lord,
the petitioner?
My lord, there are 60 days, 60 plus 30, 90. They have calculated, my lord.
Petitioner has calculated. And you have paid by taking into calculation only 60 days?
My lord.
Kindly read paragraph C of 6.
C of 6. Moreover, the Union of India, BSF, filed a special leave petition 18357 /58 2016 before the Honorable Supreme Court of India with the prayer to grant an interim ex parte stay of the operation of the final judgment dated 28/8/2014 passed by the Honorable High Court of Jharkhand in LPA number 415 of 2008 and the final.
What has that got to do with?
Your Lordship, this issue actually is sub judice before the Supreme Court at the moment.
Which
This,
issue?
this very issue, Your Lordship.
What issue? The petitioner prays for calculation of his earned leave. You
Yes,
cannot
Your Lordship.
calculate.
So whether he is entitled in the manner that he is proposing or not, this very issue is sub judice before the Supreme Court, Your Lordship.
Please come. The petitioner's prayer. The petitioner is a retired member of the Border Security Force. Stop. He has made a representation before the commandant of his battalion seeking a direction for calculation of his entitlement of earned leave. Stop. He said representation is pending consideration. Stop. Learned advocate for the petitioner relies upon the Border Security Force leave rules, 1971. Was earned leave given to you?
Yes, my lord. Now
How many days?
Kindly see the rule 3 says in 1st January I will get, my lord, 30 days leave, and in 1st July I will get another 30 days. So in a year it is 60 days. Now if earned leave is not availed, it would be carry forwarded to the next half. Subject to condition, total earned leave must not exceed 120 days. Now at page 36, kindly see how their calculation is erroneous. It says on 1st April 1987, I joined. So I, my lord, got 3 months earned leave.
Do not go to the details. You tell me how many days you earned leave was calculated for you.
That is, my lord, kindly see, they have lapsed on a considerable period after 1st January 2005 to 1st.
In support of his claim. Stop paragraph. As it appears that the prayer of the petitioner is pending consideration before the commandant, accordingly the instant writ petition stands disposed of by directing the respondent number.
Respondent number, my lord.
4. To take a decision on the petitioner's prayer strictly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner. If any amount is found due and payable, the same shall be paid to the petitioner immediately thereafter. This representation to be forwarded.
I'm grateful, dear Lordship.
158, I appear for the petitioner, my lord. My lord, an unfortunate incident has happened, my lord. I'm unable to trace the brief, my lord. If my lord, I have requested learned colleague to provide me with a brief. If my lord, I am praying for adjournment.
Adjournment for how many days?
My lord, can it be taken up, my lord?
Next week?
Yes, my lord. My lord.
All right, not this week.
Deeply obliged, my lord. You 159 as well, my lord.
158, 159.
All right, both, not this week.
Deeply obliged, my lord.
Next. Yes.
I have submitted the last occasion when the determination was
Now the determination is here?
Yes.
All right, what is the matter?
My lord, may I submit, my lord? Mr. Shomo Mojumdar is appearing for the petitioner, my lord. Both the matters, my lord, he is engaged in another court. If your lordship kindly keeps it, not today, my lord.
But there is another learned counsel also, isn't it?
But as far I have heard, my lord, Mr. Shomo Mojumdar is appearing for.
Not today.
The second item.
I see second item. All right. Not today?
Not today, my lord.
All right, not today.
Grateful.
Has the report been filed?
Yes, my lord.
All right.
Hmm? May I give the name?
162.
Lord, I am appearing for the Union of India.
Please enter your appearance. The writ petition stands dismissed for default. Same, dismissed. Dismissed.
My Lord, I am for the respondent.
Give your appearance. Dismissed. 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 Union of India, please enter your appearance.
167. Lordship, I am appearing for the petitioner. The Lordship, in this matter, this is a case
167. Who is your other side?
Union of India, Your Lordship.
Union
I've
of
asked
India.
also, they also did not.
Mr. Anil Kumar Gupta is representing Union of India, ma'am.
Who is Mr. Preetham Roy?
Ma'am, Anil Kumar Gupta.
Are you aware of anybody named Preetham Roy? I can see his appearance recorded as for the Union of India.
No, ma'am, I don't know, ma'am. Just praying for the adjournment, ma'am, for 2 weeks.
What is your grievance?
Lordship, this is a matter of denial of promotion on account of past penalty of censure despite the promotion order being made. Petitioner is a constable in CISF.
So without the respondents, it cannot be heard, isn't it?
As your Lordship may deem fit.
Because their stand is to be taken into consideration.
On last occasion also they had sought an adjournment for.
Accommodation has been sought for on behalf of the learned advocate representing the Union of India. Stop. It appears that on the earlier occasion also, accommodation was sought on behalf of the learned counsel for the Union of India. Stop. For ends of justice, what is your name?
I'm Vikash Agarwal.
It is your name that will go down and not Mr. Gupta. Hearing of the writ petition stands adjourned till 6th of April. Stuff. It is made clear that in the event the Union of India is not represented on the adjourned date, the necessary order will be passed in its absence.
My Lord, I am appealing for the petitioner, my Lord. My Lord, the petitioner is, my Lord, retired employee of the, my Lord, West Bengal Transport.
I am appearing.
My Lord, earlier, my Lord, Calcutta Tramways Company, my Lord. He is a pension holder, my Lord, since 2010, my Lord. My Lord, on 15th of, my Lord, February 2021, my Lord, the Transport Department, my Lord, came up with a memorandum, my Lord, whereby, my Lord, his pension was, my Lord, revised in the terms, my Lord. It is there in, my Lord, page 23, my Lord. The terms is, my Lord, whoever the pensioners, the employees retired before, my Lord, 1st of January 2016, my Lord, their pensions would be, my Lord, revised. My Lord, the basic pension would be, my Lord, multiplied with, my Lord, 2.57, my Lord, and the commuted amount, if any, my Lord, that would be, my Lord, deducted from that, my Lord. That is there, my Lord. May I show your Lordship page number 23, my Lord. A, my Lord, bottom, my Lord, that point A, my Lord. May I place it, Lordship? Revision of pension, family pension of pre-1.
What is the problem? Please tell me.
My Lord, I am praying for, my Lord, revision of my pension, my Lord.
In terms of this memorandum?
My Lord.
And they are not allowing it?
No, my Lord. Till now, my Lord, till date, my Lord, it has not been allowed, my Lord. Earlier occasion, one writ petition before, my Lord, Honorable Justice Shogoto Bhattacharya, my Lord, order had been passed, my Lord, directing them to, my Lord, pay.
And you want
only one.
similar order to be passed
Yes, Millard.
here?
Only one aspect, Millard. May I point it out, Millard? Since, Millard, that is to be paid notionally from 1/1/16 to 2019, that is notionally, with effect from 1st of January 2020 onwards. But since this memorandum came up on, Millard, 15th of February itself, 2021, since the respondent corporation did not know about it, so, Millard, that interest component, Millard, should be, Millard, paid. I would be paying, Millard, from 16th of, Millard, February 2021, Millard, not before, Millard. Though the amount they would be paying, Millard, from 1st of December, 1st of January 2020, Millard. That is also recorded in that, Millard, order also of Lordship Justice Bhattacharya. এগুলো হয়ে গেলে দিয়ে দেবো তোকে।
Yes, respondents.
My lord, I'm for the corporation, my lord. My lord, will kindly see this. First of all, my lord, this issue has already been settled by the coordinate bench of this honorable court. So, my lord, I cannot really stand in the way. Next, my lord, this memorandum at page number 23. This is the memorandum issued by the Transport Department, Government of West Bengal. So, my lord, it is routed through me, but I'm not the author of this memorandum. Now, my lord, if the government, if the state of West Bengal has decided to revise the pension, my lord, I can only propose the name so that the funds can be sanctioned and I can make the payments to the concerned petitioner. So that is what, my lord, we have been doing since the order referred by my learned senior has been, my lord, placed before your
Are you
lordship.
aware of the order that has been referred?
Yes,
It is
yes, ma'am.
Shopon Ghoshal.
Yes,
WPA 18812 of 2025, and the order date is 23rd of February 2026.
Yes, ma'am. I
So
had also
similar order. Yes, your appearance is recorded. So
Yes.
similar order can be passed.
Yes, ma'am.
And the interest part is also recorded over here.
My lord,
Yes.
my lord.
Please come. The petitioner is a retired employee of West Bengal Transport Corporation Limited. Stop. He prays for a revision of pension in terms of the memorandum dated 15th February 2021, issued by the Transport Department, Government of West Bengal. Stop. The prayer of the petitioner for grant of for revision of his pension is pending consideration before the concerned authority. Step paragraph. Learned advocate for the petitioner relies on the order dated 23rd February 2026, passed by this court in WPA 18812 of 2025. Shopon Ghoshal, alias Shopon Kumar Ghoshal versus State of West Bengal and others, wherein a similar issue fell for consideration before the court. Stop. After hearing the parties, the court was pleased to direct the West Bengal Transport Corporation Limited to grant benefit of the subject memorandum within a stipulated time period. Stop. The court also directed the said authority to grant interest at the rate of 6% per annum on the revised pensionary benefit on and from the next date of the subject memorandum, that is 16th February 2021. Stop. The state respondents were directed to allot necessary fund to the Transport Corporation Limited for making payment. Stop paragraph. As it appears that the facts of the case are similar to the case mentioned herein above. Accordingly, similar direction is passed in the instant case. Stop. The West Bengal Transport Corporation Limited is directed to grant benefit of the memorandum dated 15th February 2021. By revising the pension of the petitioner, by applying the methodology as contained in clause 5.
5 minutes.
Clause 5 of the said memorandum within a period of 8 weeks from the date of communication of this order. Stop. As the revision of the pensionary benefit ought to have been taken immediately upon publication of the subject memorandum, but the same has not been taken till date, accordingly, the petitioner shall be provided simple interest on account of such delayed payment of the revised pension amount at the rate of 6% per annum, calculated on and from 16th February 2021 till the date of actual payment. Stop. The revised pension shall be paid along with the interest. Stop. The state respondents are directed to allot necessary fund to the Transport Corporation Limited for making payment to the petitioner in terms of the direction passed herein above. Disposed.
I'm grateful, Your Lordship. Millard, last occasion, Millard, since the state respondents were not there, Millard, I was directed to Millard serve them afresh.
All right.
So I have first served Millard.
None appears for the state. Affidavit of service filed in court is taken on record. Despite service of notice upon the learned advocate representing the state.
168 which. Huh? Achha.
Same order will go down in the rest of the matters.
My lord.
Call one by one.
May I, Your Lordship, my lord, beg your pardon, Your Lordship, my lord, just the preceding matter, my lord, 167, my lord, I am for the respondents. Your Lordship was looking for the respondent, my lord, I was rushing from courtroom number 29. I could not reach in time, Your Lordship. So, my lord, Your Lordship has passed an order, my lord. The respondent is present, Your Lordship, for the CISF Union of India, Your Lordship.
Next day, you make your submission. 169.
Lordship. Millard, only one difference, Millard. The petitioner is Millard, the widow of the Millard
employee.
Pensioner. Yes, Millard. She passed away on Millard 10th of February 2018.
The petitioner is the widow of the pensioner. বলে rest portion টা her husband retired from service বলে ওটা পুরোটা দিয়ে দেবেন. All right, next.
I'm grateful, Lordship.
Here also, sir, are you there? No, Maya,
170.
170? 69, nobody is there. None for
Millard,
this state.
she is also Millard, the widow, Millard. Next item, Millard.
170?
Yes, Millard.
All right, widow.
My lord, I'm appearing for the state in 171. Similar matter.
170.
This is 170 going on. 170.
Millard, 171, she is
170 state is there.
Millard, 1 is also Millard widow.
71 also widow.
My lord.
All right, widow.
My lord, I'm appearing
For the
in all
state
the
in
matters
171, my
for the corporation.
In all the matters.
Yes.
Yes. 171 appearance recorded.
172 employee, Millard.
Employee has come. No, none for the state.
72. 173 similar, Millard.
Employee has come.
My lord. 173 similar, Millard. 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 1 Similar.
Employee has come.
For this.
Yes.
State, give your appearance. All right, same order.
I beg to appear. I beg to appear on behalf of the respondent.
Is 176 the same matter?
Same.
All right.
Yes.
For the statement.
Give your appearance, 176.
I'm grateful,
same.
Your Worship. I'm grateful.
Grateful.
She a widow?
No, Milan. She is employee.
All right. Amol Kumar Khan.
I'm grateful. 176.
176 ta niye ninto? All right, 175.
175, I am appearing on behalf of the petitioner. Petitioner is claiming the retirement benefit of the deceased husband. She made a representations before the concerned authority on 30 June of 2025. During the lifetime of the petitioner's husband, the husband made also 2 representations before the same authority, but the grievance
When
was
did
not.
your husband retire?
The retired husband paragraph.
And what are the dues according to you?
The husband retired on compulsory retirement on 11th December 2015. 2015. And as per representations, second page 31, the following retirement benefits arrears of salary from 2002 to 2015, stagnations increment as per bipartite settlement from 2003 to 2015, fixed personal pay from 2002 to 2015, and gratuity of entire service life, proportionate commutations of pension.
From 2002 to 2015, what was the employee doing? Why was salary not being paid to him?
So far, I know that there was some disciplinary proceedings or something like, but no documents was provided.
And what is the final result of the disciplinary proceeding?
That was here I have asked, but there was
Compulsory retirement from the service.
compulsory retirement. That is averted in the
Guilty and he has been
compulsorily retired.
Yes.
And at the time of passing order, did you make any statement that he will not be entitled to his previous salary or anything of that sort from 2002 to
yes,
15?
even in the they have made a representation after considering the same. Since the employee was retired from the compulsory retirement, though he was not entitled to, but some increment was there which fallen kept pending for consideration. After find him a guilty, the entitlement which the petitioner entitled to, the bank has also released in the month of April 2025. Released.
In favor of the
Yes,
petitioner?
in favor of the petitioner. This fact has not been disclosed in the writ petition, subject to correction. In the month of April, I have a statement of account which has been released in favor of the petitioner. Rita Chatterjee.
This representation was received by you long back in July. Why did you not give a reply and say that this is payable, this is not payable, this has been
bank
paid?
has already disposed of it.
Disposed of this?
Yes, even the entitlement which they are.
Where is the response to this representation?
Let's say I will file a report to that effect.
What is the use of filing a
petitioner has
report?
not received any.
1 minute. The representation is there.
Yes.
Good, bad, indifferent. You take a decision and let him know so that his next avenue opens. Otherwise, nothing.
Can he pass an order for disposal of the representation?
Considerations of the.
We will do the same. If not.
Please come.
If not.
The petitioner is the widow of an employee of the bank who was compulsorily retired from service in the year
2015. 11th
who
December.
expired in the year 2020.
2024 to 26th April.
Yes, sir. According to the widow, certain service dues have not been paid by the bank to her husband. Stop. A detailed representation dated 30th June 2025 has been addressed to the authorities of the bank. Stop. Grievance is that the same has not been considered till date. Stop paragraph. Learned advocate representing the bank submits upon instruction that the due of the employee which was found payable has already been disbursed in favor of the widow.
Nothing
Stop.
due enough. Nothing due.
As on date, no amount is due and payable to the employee. Stop paragraph. Be that as it may, as it appears that a formal representation seeking release of the dues of the employee is pending consideration before the bank, accordingly, the court is not inclined to enter into the merits of the same at this stage. Stop. The instant writ petition stands disposed of by directing the Indian Bank.
What's the Indian Bank? No.
The chief manager will be the appropriate authority. Respondent number 6, page 3, please see.
Chief manager, sir. I've seen. Page 6.
Page 3, respondent number 6.
Chief manager, Government Office, Allahabad Bank Building. This building, 37 block A, managing director, Indian Bank. Lordship. Yes.
The respondent number 6 is directed to consider the representation filed by the petitioner strictly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. The aforesaid respondent shall clearly indicate the dues, if any, payable to the employee and disburse the same without any further delay. Stop. If the claim of the petitioner is not accepted by the bank, then the reason for non-acceptance of the same shall also be disclosed.
Yes. Okay.
My lord, I am appearing on behalf of the state. My lord, in this matter, earlier subordinate feels to directly appear in the master list of everyone. That's petition is not.
এপ্রিলে আসতে বলেছে দেখুন তো
25th February.
See, it is April has been struck off and it is mentioned March.
Then
Lord, I'm sorry. I'm for the petitioner, Lord.
Yes, what is the matter?
My Lord, this pertains to, my Lord, my Lord, past in, my Lord, there was a criminal case pending which prevented me, my Lord, from joining in the post of constable. Lord, it removed me from the zone of consideration. Now, my Lord, on the last occasion, this matter was taken up. And, my Lord, it was expressed by the Honorable Justice, my Lord, as was presiding there. My Lord, that, my Lord, instructions will be taken by the state respondents to find out whether, my Lord, there is any vacancy or not.
There is no question of vacancy, my lord, because the panel is for the 1 year. And validity of the panel is 1 year, and that has come. This 2017.
I see it is recorded, your submission is recorded that there is no impediment in engaging the petitioner as home guard. This is recorded in the order.
My instruction is because, my lord, then because he has exonerated for the criminal case.
Yes.
But why, my lord, I don't know. My lord, validity.
What you don't know?
Because the validity of the panel is for 1 year.
When was the panel prepared?
My lord, in the year 2017.
17?
Yes.
And when was he exonerated?
2024.
24.
2025. Made
So
taxes.
get the benefit.
Lord, thereafter I made the representation because I was
What?
removed from the zone of consideration. Then, my lord,
Obviously, because had it been that you were exonerated prior to your police verification report, then it would have been otherwise. The proceeding, the panel was prepared in 2017. You get exonerated in 2024, and you say that you'll get the benefit of that order. Certainly not.
Yes, my lord.
Please come.
Apart from
may this be taken up tomorrow, my lord. Today, my lord, I am under some difficulty, my lord. Today, I am under some difficulty, my lord. May this be taken up tomorrow, my lord. I can try
You
and
did
assist.
not seek adjournment at the very first go.
May I-
When the order is going to be passed, you seek
From the-
adjournment.
If your lordship pleases, my lord, to take it up tomorrow, my lord.
Come tomorrow, not today. এটা ফেরত দিয়ে দিন।
So deeply obliged, my lord. I apologize, my lord.
Not today.
Deeply obliged, my lord.
178.
May not be playing for dinner, not today.
Why?
Minus here, counsel is not well. Very sick, my lord. Sir.
Microphone.
My senior counsel is not well. He's very
Not well.
Yes,
The
he's sick.
senior counsel was present in the morning, and now you say he's not well.
No, my lord, sir, he's very sick, my lord, sir.
Very sick? No.
Sick. Yes, my lord,
He's
sir.
not sick.
No, my lord, sir. I'm paying for not today, my lord, sir. Kindly give note tomorrow.
Tell him to join online.
My lord, sir, kindly tomorrow.
Tell him to join online.
My lord, sir.
179.
Consider prayer, please. Consider.
179.
Yes, yes, I am appearing on behalf of the petitioner. my lord.
Yes.
This matter relating to my lord, PSC, my lord, WBCS executive appointment and selection process, my lord. My lord, kindly turn page number 26. That is the advertisement. West Bengal Civil Service Executive Examination 2023.
Yes.
My lord, second column in tabular chart. Particulars and certificate required for EWS certificate. 1. A candidate claiming to be EWS must have a certificate in support of his/her claim from a competent authority of West Bengal issued on or before 31st December 2023. And no claim in this regard will be entertained afterwards. So there is a specific date within the stipulated time. If a person is having the EWS certificate, then only he claim as an EWS candidate, my lord. Kindly turn, my lord, page number 28. What's my declaration? Column 6.
Yes.
My lord, EWS, yes.
Issuing date.
Yes, my lord. Kindly turn, my lord, my EWS certificate issuing date, my lord, page number 25. My certificate. 12 September 2023. So within the stipulated time. What happened, my lord, in this selection process, the confusion created by the PSC itself. Why? My lord, after participation in the selection process, my name featured in the list. That is, this is a three stages selection process. One is preliminary, thereafter main, thereafter interview. My lord, kindly turn page number 29. This is a preliminary, successfully completed the preliminary examination. Thereafter, their name featured in the list. My name also featured in the list. In column 3, the middle portion, my roll number is 2506604.
Which column do I get that?
My lord, I just, my lord, up 1,
Page
2,
29.
3, 4. Yes, my lord. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Which column you tell me?
Third column. Third column, my lord, in middle portion, 2506604. But in my
yes,
got it, my lord. So my name featured in the successfully completed the preliminary examination, and thereafter my name featured in the list. Thereafter, my lord, another notification which is annexed in the petition, that is page number 30.
Yes.
Sorry, kindly turn page number 32, from where the whole confusion created. Before that, kindly turn page number 34. That is main examination. After we successfully completed the preliminary examination, thereafter my name also featured in the main examination list also. Page number 35. They are also in third column. So I successfully completed preliminary examination, thereafter main examination, thereafter I participate in the interview also, and my name featured in the interview list, page number 37. Date 11 November 2025, entry 11, serial number 11, Sotto Sadhan Mondol, right? Sotto Sadhan Mondol, yes.
Yes.
Entry 11. So, my lord, my name featured throughout the list. Thereafter, my lord, my name not featured for giving recommendation. Why? The confusion created. Why? My lord, in other candidate, kindly turn page number 37 and stay for a time while. In others candidate, suppose Shorop Maiti, status EWS. Others candidate Sukanto Chakraborty, status EWS. In my name, against my name, there is no status of EWS. Thereafter, my cause of action arose. Why? Because of that, in the interagnum period, PSC give a notice, and that notice is page number, which I want to show. Page number 32. The whole confusion created by this notice, page number 32. I just read it slowly, my lord, and the second paragraph is most important. Because on the last cut-off date, I was a EWS candidate. And this is a well-settled legal principle that on the last cut-off date, if I have the requisite qualification or requisite certificate, then they ought to declare me as a EWS candidate. Here, my lord, in page number 32, my lord, Public Service Commission, they subsequently, after closing of the online application last date, they issued this notification. Why? I just read it, my lord. Important announcement in connection with West Bengal Civil Service Executive ETC Preliminary Examination 2023. A number of applications have been received from several candidates who stated to belong to EWS category could not find their roll number in the EWS category list due to server stroke technical error. So whose error? That the authority's error. Although they stated to have obtained the cut-off marks 84.50 or more than cut-off marks in the EWS category. My name featured in the list.
EWS category.
No, Mala, that is one singular
list.
Combined list, because preliminary list is a combined list, because there in the preliminary list there was no mentioning of EWS or non-EWS. My name featured on that list, whether I am featured as an EWS or non-EWS, how could I know? I did not know. Even in the main examination, after main examination, they are also not mentioning EWS. After interview, when interview was taken, on that list only, there was mentioning EWS. So, my lord, kindly, I read it the whole notification. Why the confusion is created. In order to ensure absolute transparency, all the candidates belonging to the EWS candidate who have obtained the cut-off marks or more than the cut-off marks in the said examination, but whose roll number have not figured, but my roll number is figured. If my roll number not figured, then only I could say that yes, my name not figured, that's why I went there and thereafter I rectify it. No, my name featured, whether they featured my name as an EWS or non-EWS, how could I know? Not figured in the list of the qualified candidate belonging to EWS category are requested to bring their original EWS certificate issued by the appropriate authority within the closing date, that is 31st December 2023 of EWS status, and the original printout or copy of the EWS application form filled up through PSC WB web portal only, along with original identity proof and application form of the WS examination 2023. So, whose name is not featured in the list, but my name is featured in the list. How could I know they not featured, my name featured, whether as considered as a EWS or non-EWS? All such applications should be submitted positively by 11th August 2024. Throughout my EWS certificate within the stipulated time, I filled up the form as an EWS candidate. My name featured in the preliminary list, main examination list, thereafter in the interview list. And the last part in the interview list, my name was not featured as an EWS candidate. Thereafter, my lord, I immediately came to the court, my lord. So my respectful submission is that, my lord, within the stipulated time, I filed my EWS certificate. I declared me as an EWS candidate. And this is an well settled legal principle. And in our court also, several orders passed in this regard, my lord. I just don't want to, my lord, give so many citations because just one or two, my lord, division. But there are, my lord, no, my lord, Ashok Kumar Shonkar, my lord, 2007 4 SCC 54, para 11, 15, 16, and 20, and one unreported of our High Court. Matt, ওনাকে একটা copy দাও। I have 2 copy only. Para 10 and 12. Just I may read, my lord. আমি পরে দিয়ে দিচ্ছি। Just I read, my lord, 2 paragraph. Para 10 and 11. Yes. এগুলো দেওয়ার দরকার নেই আর। প্যারা 10 and 11 মানে I just not read it. ये অশোক সনকারটা দিয়েছে। প্যারা 10 and 11 একটাই আছে।
This is Somnath Pramanik that you've handed over.
Somnath, no, my lord. Yes. Yes, my lord. Somnath Pramanik. Just that matter, my lord. Whether within the stipulated time, if there is, and my lord, Ashok Kumar Shonkar, 2007 4 SCC, para 54.
Paragraph?
Sorry, page 54, paragraph 11, 15, 16, and 20. Paragraph 11. The question as to what should be the cutoff date in absence of any date specific in this behalf, either in the advertisement or in the reference in no longer res integra, it would be the last date for filing of application and would appear from the discussion made herein after. Now, para 15. Para 14. A review. The said decision is therefore, there is a para 14. A review application was filed with which and admitted the matter was again placed before the 3 judges bench of this court in Ashok Kumar Sharma versus Chandrasekhar. One of the issue which fell for consideration of the bench being issued.
Right, this is very
well settled principle. Para 15, 16,
yes,
20. This is well settled principle. On the last cutoff date, whatever my declaration, that would considered as a candidature, my lord. So I fill up the form as an EWS candidate, my certificate within the stipulated time. So considered me as an EWS candidate, my lord. That's my respect.
You are for PSC. Yes.
Due to some technical errors, my lord, it is glitched. Can you turn to page 32, my lord?
Yes.
Number of candidates belonging to EWS, although they had uploaded their documents on the website of the commission, my lord, but these were not reflected. So, person to receiving of certain representation from different candidates, my lord, this notification at page 32 was issued, my lord. And there was a cutoff date mentioned in notice itself. That was on 11th of August 2024.
But this, who had to apply in terms of this page 32? Who were supposed to apply?
Well, those whose names were not there as EWS candidates.
Right. Now, petitioner's name was there in the list.
Yes.
Do you have a separate list for EWS candidates? Or is it the list which is annexed to the writ petition?
Well, it's a preliminary list. There, no category is mentioned.
No category is mentioned. So petitioner's name is there already?
Yes.
Petitioner's roll number is there? Why is the petitioner required to make further application?
Well, there have been difficulty with regard to number of EWS candidates.
That is your difficulty. That is not the petitioner's problem. He appeared, he filed his EWS certificate, and His roll number features in the list of selected. The candidates eligible for the next recruitment
Kindly turn to
stage.
Page 32.
32.
33, my lord.
Yes, 33.
Pursuant to that notification at page 32, my lord, number of candidates belonging to EWS had applied before the commission for verification of the
So
documents.
what? Let them appear. Let them apply. No problem. You treat the petitioner also as EWS candidate because he has a certificate.
Made representation to the authority.
What is the stage of the recruitment process?
For my instruction is concerned, my lord, possibly on 21st January, the final list has been published.
All right. Now, if there is no error on the part of the petitioner, how can you disentitle the petitioner from claiming the EWS
My lord,
status?
this notification was there, my lord. It was known to the petitioner. Can you turn to page 31?
It hardly matters whether the petitioner was actually required to submit an application.
Because petition was not the only one. The number of candidates were there whose EWS category status was not successfully uploaded on the website. That was the reason. But pursuant to this notification, on page 33, you will find that 101 candidates have been.
Did you file your report?
No.
You file a report by 2 weeks. Please come.
My lord, may I press this court? This is 21st January, my learned friend, my lord. Rightly says 21st January 2026 is the date. A notification issued by the PSC. The following candidates have been recommended for appointment in different Group A service mentioned below on the basis of the result of the West Bengal Civil Service Examination 2023 Group A service. My name ought to featured in this list, but not featured due to non-consideration of EWS, my lord. My lord, my instruction is that, my lord, till date, the appointment, although recommendation
have not been issued.
That's my own instruction because I have no specific, my lord, notification in this regard.
All
So
right.
it will be kind enough, my lord, one post kept for this
All right.
candidate, my lord. That will be okay. Every service on the kept.
The petitioner participated in the West Bengal Civil Services within bracket EXE.
নাম্বারটা দিয়ে দাও দাদা
Within bracket executive.
Okay.
EPC examination 2023
Okay.
in the EWS category. The petitioner was in possession of a certificate issued by the Additional District Magistrate within bracket DEV, Purba Bardhaman, dated 12th September 2023 for the financial year 2023-2024. As per the recruitment notice, a candidate claiming to be EWS must have a certificate in support of such claim from a competent authority issued on or before 31st of December 2023. The petitioner's roll number was included in the list of candidates qualified provisionally for the personality test and thereafter in the interview. The status of EWS, however, was not disclosed in the list published for interview of the candidates. Did you appear in the interview?
Yes. Well, then successfully
appeared in the interview on 11th of November 2025, but his name has not been published in the final list of recommended candidates.
Even I filed this before interview, date of
Yes.
interview, I filed this writ petition.
I have seen that. Published by the Public Service Commission on 21st January 2026. Stop. It has been submitted that though the recommendation has been issued, comma, now it has been submitted that though the list of candidates recommended for appointment has been issued on 21st January 2026, comma, but the letter of appointment has not been issued in favor of any candidate till date.
But I have not received any instruction with regard to the
Stop.
upon that.
Learned advocate for the petitioner relies on the judgment delivered by the Honorable Supreme Court in the matter of Ashok Kumar Sonkar versus Union of India and others, reported in 2007 for SCC, page 54, wherein the court, in no uncertain terms, held that in the absence of a cutoff date specified in the advertisement, comma, the last date for filing the application as would application would be treated as the cutoff date for consideration of the certificate.
Penultimate paragraph, para 20.
Yes, next. Prayer has been made to direct the respondent Public Service Commission to keep one post in the EWS category vacant in the event petitioner is able to succeed in the instant writ petition. Stop paragraph. Learned advocate representing Public Service Commission submits that a notice was published by the commission. Where was this published? In the website?
Website.
In the official website.
8th of August 2024.
No, 21st January.
No.
Page 32 is dated 8th August.
8th August.
On 8th of August 2024.
8th of August.
Wherein it was mentioned that a number of applications have been received from several candidates in the EWS category,
whose name was
that their roll numbers in the EWS category list due to server/technical error could not be found, despite obtaining the cutoff marks 84.50 or more in the EWS category. Stop. In order to maintain absolute transparency, all candidates belonging to the EWS category who obtained the cutoff 84.50 marks or more, but whose roll numbers have not figured in the list of qualified candidates belonging to the EWS category, are requested to bring their original EWS certificate issued within 31st December 2023, along with original identity proof and application form in the Office of the Commission by 11th August 2024. Stop. It has been submitted that as the petitioner did not produce the original EWS certificate in terms of the aforesaid notice, comma, the candidature of the petitioner has been treated in the unreserved category. Stop. Is your marks disclosed anywhere?
No, my lord, as per my knowledge goes, my lord.
No marks.
Not even in the recommendation list also. Never. Maharaj, there are Maharaj,
In
there
that
are
case, how will the candidates get to know how much they have obtained?
every time, Maharaj, in PSC, Maharaj, this type of authority, they insist the candidate made the RTI application, and thereafter.
1 minute. This notice is dated 8th August. You want the applications to be filed by 11th. You say that those who has obtained cutoff or more. How will a candidate get to know what is the cutoff? Within 2 days, certainly the RTI applications reply will not be made. How will the candidates get to know the cutoff?
Pursuant to the notification, number of candidates that apply.
That means everybody
Resume.
submitted the application without even knowing what is the cutoff, whether they secured cutoff, whether they were not in the cutoff rank. Everybody who were there in the EWS, they have submitted application. But is this the way? How do you find out candidates? Or how will the candidates get to know how much they have secured in the examination? No way. Yes, sir. On a query of the court, learned advocate appearing for the commission admits that the candidates did not have the scope and or opportunity to know the marks secured by them in the examination as the preliminary examination, as the said marks were not disclosed in the public domain. Stop. Nor any personal intimation with regard to the marks scored by the candidates was made known to them individually. Stop. It has also been submitted that the preliminary list that was published did not contain any mention about the reservation status of any of the candidates. Stop. The paragraph. According to the commission, several candidates filed their applications within the stipulated time period, that is 11th August 24, in response to the notice issued on 8th August 2024. Stop. Paragraph. To decide the issue as to whether the petitioner would be entitled to get the benefit of reservation under EWS category, the respondent PSC is directed to file a report by way of affidavit disclosing its stand by 17th April. Release the matter on 27th April 2026. As it appears that a list of recommended candidates has already been published in January 2026, and the instant writ petition was filed on 10th November 2025, to preserve the right of the petitioner to get the benefit of reservation, in the event the writ petition is disposed of in his favor, the respondents are directed to keep one post in the EWS category vacant to accommodate the petitioner. Stop. Anything else?
No.
Any further direction? Whatever you've got to say, you say by way of an affidavit.
Extremely good.
And keep this in mind that you have not disclosed the marks of any candidates, and it will.
Marks have been disclosed.
It makes no difference. You publish a cut-off marks. How do you get to know whether you secured more or less? Next.
Kindly record the affidavit of service.
Yes, yes, service is taken on record.
There's two affidavit of service.
All right, 2 affidavits of service. Yes, 180. Is it a similar issue?
No, no, this is regularization.
All right.
Is this matter, this matter relating to regularization of WBSRDA assistant engineer. But before that, there is a similar matter like yesterday's matter, in respect of the notification issued by the state government, every deliberated or contractual worker ought to get the benefit of 2024 notification. What happened, most of the departments, some of the department they did it, the annual enhancement. They were although giving the basic, that is 37,000 or 25,000, the respective year. If he completed 15 years, so he get 15,000 or 25,000. Kindly turn that notification, which is annexed in my reputation, page number 92.
How many years of service this?
I made a tabular chart, page 6 and 7. I made a 2 tabular chart, how many days we complete, for inconvenience. Page number 6, date of appointment is mentioned, salary amount, and the page number 7, kindly turn how many years we completed in the meanwhile, every petitioner here in the date of joining is mentioned as well as year of service, that is mentioned, kindly turn page number 92, that is 2024 memorandum, on completion of 15 years, 30,000. So they give the 30,000, but the annual enhancement, suppose he complete, suppose petitioner number 1 completed 17 years, 2 months. That means almost 18 years. So 3 years, that means 900 into 3, that means 2,700. Last occasion on the last matter also, the department gave the clarification, but they not give that announcement. So, for the interregnum period as an interim relief.
Yesterday's order can be passed.
Yes,
Sure, give me that number.
Yes.
Is it put up in the server?
Not yet. Not yet.
Not yet?
Not yet.
Should
Twin
have
Kanti
been-
Banerjee. Twin Kanti Banerjee.
Should have been. Give me the number.
And for the regularization, they filed the affidavit. Clarification of department, yes. Morning I checked it, but morning
No, by now it should have been
night
there.
should. ये देखो WPA 3468 of 2026.
এই দেখুন তো
3468 of 2026.
3468 of is Shailesh there?
2026. Oh, so yes, it is uploaded. Now it is uploaded. Yes, but department is different, That is youth
That
services.
is
It is
different.
WBS.
But then the issue is same.
Issue is same. West Bengal State. Oh. Yes. And I also annex a judgment in this regarding regularization. That is page number.
That they will.
Yes, ultimately they can deal.
Yes. They, please give me printout, please. Mr. Dhol, a similar matter was taken up for consideration yesterday. And an order, 2 prayers, regularization and enhancement of remuneration, the yearly enhancement that is being made. Right, regularization, you submit your opposition, and this enhancement, the memo is here. You have to take steps in terms of this memo.
My lord, whether they are eligible or not, that
Find out.
that is to be considered. My lord, the
Listen.
memo is also, my lord, subject to
Listen.
guidelines.
The fact that they will be eligible because the earlier memos have been allowed. It is not for the first time that they will be getting
And
the benefit.
not only that, my lord,
So enhancement was given earlier.
and not only that, my lord,
Followed.
I got the remuneration.
Had it been a case that it is for the first time that seeking for the enhanced remuneration, then the question would have been the entitlement of the memo, but it is not so.
What difficulties they have because of their thought of this annual enhancement is means one time. They're not thought of that clarification, my lord, in that matter, my lord, in Tuhin Kanti Banerjee. That's why the department asked for the clarification and the department gave that clarification. Yes, it ought to be added as an annual increment.
Here they are serving in
Multiplying
the
yes.
Panchayat and the Rural Development Department.
Yes.
Petitioners are?
My lord, West Bengal State Rural Development Agency.
State Rural Development Agency, WBSRDA. They are daily rated or contractual?
Well, contractual.
All right, please come.
Everyone.
I think the agency, because I think that there is
WBSRDA. West Bengal.
Petitioners are contractual employees of West Bengal State Rural Development Agency. They are in service for a considerable period of time. Stop. The number of years spent by the petitioners in service has been tabulated in page 7 of the writ petition. Stop. They seek regularization. Stop.
ওটা তো ইয়ার টু ইয়ার চেঞ্জ হয় না ওই জন্য তো ট্যাবুলার চার্ট বানানো হচ্ছে
The petitioners, paragraph number 6 will be there. Petitioners have, however, been provided the benefit of enhancement of remuneration from time to time in terms of the memorandum published by such and such. The petitioner submits that they are not being provided the benefit of the enhancement of remuneration in terms of the memorandum dated 1st March 2024, annexed at page 92 of the writ petition.
My lord, kindly please page 6. The salary which they are drawing.
No, madam. This is salary which was at the time of engagement. That was the salary.
My lord, there should be one statement saying that I am getting that.
Yes, obviously. That is with the tabular chart. I am getting that.
Chart does not say reveal that you are
30,000 you are getting?
Yes, yes.
I'll record.
Yes, yes. Madam, as per the memo, the remuneration, consolidated remuneration I am getting.
30,000?
Yes, yes.
All right. The petitioners are already getting the consolidated remuneration of rupees 30,000 per month.
No, madam, not 30,000. My lord, kindly see in respect of respective year. That's why, my lord, I made two tabular chart. One is page number 6, another one is page number 7.
Completed 15 years.
Yeah, my lord, suppose, my lord, petitioner number 1, 17 years. Suppose petitioner number 5, 14 years, 8 months. So respective year, that means 5 to 10 years. So for that reason, my lord, I annex the my lord, notification, every notification.
কি বললেন ওটা?
Respective remuneration.
Yeah,
it is mentioned in the
paragraph
averment also. Their contract continue to be renewed at yearly basis without the conferment of any permanent status. It is mentioned.
Acha. For the purpose of deciding the issue of regularization, comma, the respondents are directed to prepare and circulate a report by 15th May 2026. It will be open for the petitioners to file exception to the same by 12th June 2026. Stop. As regards the enhanced remuneration, paragraph 12, which is found due and payable to the petitioners in terms of the memorandum dated 1st March 2024, comma, the authority shall take steps to release the payment in terms of the said remuneration at the earliest without any further delay.
No.
14 will remain. 16 will be there and 17 the server certified copy will be there. All right. না যেটা যেটা বললাম 6 12 14 16 all right.
Grateful.
Service is taken on record. Next.
No.
No.
Affidavit direction. There is
Affidavit.
matter.
Liberty to mention. Liberty to mention.
Yes.
Yesterday's direction, same dates.
I'm led by Topon Kumar Mukherjee is ready.
I can see you.
He is engaged in another.
Maybe
Invisible person.
let him remain engaged. 181.
181 minute I am paying for the petition.
Yes.
The
I
husband.
was told that you have fallen sick. Please tell your associates not to make dishonest submissions in court. This will be very, very bad. This is not the first matter or the last matter that you are appearing before the court. And the court will keep in mind that this type of alibis are taken to get the matters adjourned.
Why not I just came home?
Just came to know, how can this submission be made?
I came home, my lord.
You came?
From home, my lord. Just
Came from home. Where do you stay? In?
Honestly, my lord, in Bihar.
Behala. The matter was mentioned hardly 10 or 15 minutes back.
I came by the height. At that time, I was there.
Listen, no use making excuses, right? The court knows who is where and everything. Yes.
Yes, my lord, the husband of the petitioner, my lord, died in harness. He was working, my lord.
Who is your other side?
Yes, my lord. Only one difficulty, my lord. On last occasion, the honorable court directed me to serve a copy notice upon Mr. Pulokesh Bajpai. He already appeared. My lord, I verbally apprised Mr. Bajpai.
But then his name is not recorded.
In my lord, previous order, kindly may see. But I failed to make any notice, my lord. That is why he one opportunity may be given so that I make a notice to Mr. Bajpai.
None for the respondents. Released 6th April. Notice be served upon the respondents. Learned advocate representing the respondents.
Grateful.
Next. Your other side?
Service. Nobody is here, Lordship. Earlier, he was present, Lordship.
Earlier day, somebody was present?
Yes, Lordship.
Who was present?
For the Union of India.
Oh, Miss Rima Haldar. Where is she? What is the matter about?
Matter about, Lordship, the petitioner is the widow of the deceased employee, Lordship. But petitioner, Lordship, husband died in harness, Lordship, thereafter petitioner, Lordship, several times made representation, and the authority told the petitioner that there is no nomination in the service record of the petitioner, for which they cannot consider the matter, Lordship.
Consider for what?
Retirement benefit.
Terminal dues.
Yes,
All right. Then
petitioner, Lordship, got married with her husband, Lordship, in the year 82. And Lordship, invitation card P2, page 29.
Oh, invitation card doesn't make much of a difference.
It's not Lordship compelled to.
What is the title suit that you filed?
Lordship title suit, Lordship, regarding the pension.
What is the order passed by the court?
Lordship, the case was dismissed, Lordship. It was filed in the wrong forum, Lordship.
So what remains?
Even
Till
though
you,
prisoner
till your,
till late, Lordship, prisoner did not receive any retirement.
till your factum of marriage is proved, how can the authority grant you the terminal benefits?
Lordship, petitioner
Whether you are the widow of that man or not, nobody knows.
filed, Lordship, for maintenance, Lordship, and this
Maintenance, that
yes,
means
Lordship.
the
Never took
marriage was disputed.
Yes, Lordship. But till death of our husband, Lordship, there is no divorce between the husband and wife, Lordship.
Was any
And
order for maintenance passed?
Yes, yes, Lordship. Yes,
Did
that
the
is-
petitioner ever grant,
Yes,
did
yes,
the employee grant maintenance
yes,
to
yes,
you?
yes, Lordship. That is, I have annexed in the petition, Lordship. Page 30.
30?
Yes, Lordship.
Is there any other claim from any other lady?
No, Lordship.
Where did your husband work? Food Corporation of India?
Yes, Lordship. Group disturb. He was group disturb. Come to the Lordship, page 30. It started 30 to 32. 33.
Please come, none represents the respondents. Affidavit of service is taken on record. Stop. The petitioner claims terminal dues. Stop. Her husband was serving the Food Corporation of India. Stop. He died in harness. Stop. Where is your application?
Lordship.
Is there any rejection order? Formal
Yes,
rejection?
Lordship. Come to pay annex chart. P
Yes.
14, page 75.
The prayer of the petitioner stood rejected by the Food Corporation of India. Stop. The petitioner is aggrieved by the same. Stop. The presence of the Food Corporation of India will be absolutely essential for proper adjudication of the instant writ petition. Stop. Let further notice be issued upon the Food Corporation of India. Release the matter for further consideration on 6th April. Find out somebody who appears for the Food Corporation of India.
Yes, Lordship.
Kamal Chattopadhyay, a learned advocate, is there. Mr. Aniruddha Bagchi is also there. You can contact and see if anybody appears.
16 April, Lordship.
No, 6th of April.
Date continue.
Lordship, I am appearing for IOC respondent.
Dismissed. Put in your appearance, please.
Yes, Lordship.
I am for the petitioner, my lord.
I am for the state respondents.
I am praying not this week, my lord. Due to it is transferred during my lord, I have documents not available.
All right, next monthly list.
Much obliged.
Lord,
My lord, my
But by next monthly list, he will not be free. Why does not he engage somebody? The matter is pending from 2023. Then? Unfortunately? Why unfortunately?
There was a time, kindly go through the order.
The matter was taken up. No one was there from the respondents. The petitioner is here. What is your prayer?
My lord, kindly have a look at page number 34, my lord. This is the impugned order, one-page order, my lord. My lord, the petitioner was on leave, sick leave, and he was reprimanded. That is minor punishment, but his 37 days salary was deducted. That is why this petition, my lord, went to appeal as well, my lord. Appellate court has directed that let it be tried here in the single bench.
All right. So, what is the error in this order?
Error is that he was sick. He came to his native place. He was operated for gallbladder operation, my lord, and all the annexes are there, my lord. It was not considered. Those prescriptions were not considered.
Page 34.
Yes, my lord.
The order that you are challenging,
My lord.
It mentions that he pleaded guilty for the charges.
That is not true, my lord. He did not plead guilty at all. Thereafter, there was a representation and appeal. This appeal was at page 35. Kindly have a look. It has been categorically stated that he has not pleaded guilty. And this appeal was also rejected. This appeal was rejected, my lord, on 11th July 2023, when the matter was pending.
Matter was pending.
Yes, my lord.
You filed a supplementary or what?
My lord, the honorable court directed them to file a report on affidavit.
There is a report.
Yes, on
What is the stand in the report?
Yeah, there's no mentioning of my surgery at all. Although I have gone through the gallbladder surgery, it was there in my application appeal, but that was not considered at all.
Tell me one thing, does this court have the jurisdiction to decide the issue? The cause of action arose somewhere in Jammu and Kashmir.
Yes, my lord, that is why initially the court decided that it will be tried here.
Where is the order?
Justice Lopita Banerjee, my lord, kindly have a look at page number order. First order. Thereafter, Honorable Justice Kapoor dismissed the matter on territorial jurisdiction. Thereafter, it went in appeal. And kindly have a look at appellate court order, Lord. Appellate court order is in MAT 135 of 2025. Kindly have a look at the last page of the order, Lord.
Yes.
Lord, it says, I'm just going through the relevant portion. It says, my lord, in view of the foregoing discussion, the impugned order of the learned single judge, whereby the writ petition was dismissed for want of territorial jurisdiction, cannot sustain judicial scrutiny. As a result, the impugned order dated October 7, 2024 is set aside. Since the learned single judge has not dealt with the merits of the matter, we deem it appropriate to restore the writ petition to its original file and number so that the matter may be decided on its own merit. We order accordingly. This is the appeal court's order, my lord.
All right, apart from the jurisdiction issue, what are the issues raised in the
The only issue is that I was on a sick leave. Kindly have a look at page number 14, my lord. This is the first annexure, page 14. It's reason of leave, self-treatment, it says. My lord,
page 14?
page 14, first annexure,
Um,
after affidavit.
Yes.
My lord, kindly have a look at reason of leave. It is in the middle. Self-treatment. And earned leave is for 28 days. Over at the top almost. From date 4/10/2022.
Yes.
My lord, thereafter he came to his native state. He has gone through, there are a lot of treatment, including that of gallbladder surgery, my lord. And for that he was held up in West Bengal. He did not turn up at time. And from time to time he has applied for sick leave, but that were not considered at all, and he was reprimanded. It is a minor punishment, but still it will have a major impact on career of the petitioner. And moreover, 37 days salary has been deducted.
Show me your documents relating to your treatment.
My lord, yes. Kindly have a look at, start from page 15, my lord. This was treatment at Department of Government of West Bengal Hospital, Jangipur Subdivisional Specialty Hospital. This was its writing is not so legible, my lord. Prescription. These were some minor, but major surgery was done at Desun Hospital. Or no, my lord, kindly have a look at page number 21. It is complaint is pain in upper abdomen. Thereafter, it was diagnosed as gallbladder, and surgery was done, my lord. Kindly have a look at page number 26. It was from Desun Hospital and Heart Institute. Lord, admission date is 11th November 2022. Discharge date is 14/11/22. Lord, clinical summary says the chief complaint. This 49-year-old male patient admitted for planned laparoscopic cholecystectomy. That means gallbladder surgery. Patient is a known case of T2DM, that is type 2 diabetes. Brief clinical summary says patient admitted with necessary preoperative investigation. After informed consent, PSC patient scheduled for surgery. Lab cholecystectomy done under GA on 12/11/2022. Post-operative period was uneventful. Now patient is hemodynamically stable and being discharged with following advice. He was advised bed rest. Thereafter, next is page 27. This is also doctor's prescription from Desun Hospital. This is visit date is 21st November 2022.
Which page?
Next page, 27.
Yes, 27.
The visit date is 21st/11/22 because he was asked to visit the hospital. And thereafter he has written next page, page number 28. He had written to the commandant. It is in Hindi, and the next page is translation. Lord, may I read it out the translation? Page number 29.
Is your list of dates clear with regard to the dates of your absence?
List of dates. Just a second. Lord. Yes, my lord. 14/11/2022, gallbladder surgery was done. 17/11/2022, letter for extension of leave due to treatment was dispatched. This is what I was trying to impress your lordship. Page number 28. This is in Hindi, and next page is in English. May I read it out, my lord? Page number 29. I number such and such, Sudhan Mandal, 148 BNBSF, working in such Gulb. My application is as follows. I have taken 28 days earned leave on 1/10/2022. After coming home, I have suffered from a big stomach and right leg disease. Abdominal operation done, dated 12/11/2022. For this reason, I have not been able to go on duty on 1/11/2022. There has been a solution not to go on duty. It is my humble request to the respected sir that in view of my physical problem and difficulty, I have a special request to extend my leave from 1/11/2022 to 8/12/2022. I request you to give for extension of leave from 1/11/2022 to 8/12/2022. My lord, this was communicated, my lord, to the commandant, but in spite of that, besides that, my lord, email was also sent. Kindly have a look at page number 30, next page, my lord. Thereafter, again, he visited the hospital on 5/12 December, my lord. 5/12/2020.
See, from the report of the respondents,
Yes, my lord.
page 3, paragraph 4, Roman 4, at the bottom it is mentioned that the officer was operated, right, on 12th of November.
My lord is
And
referring
discharged on the 14th, page 3 of the report.
page 3, my lord.
At the bottom, can you see the dates? 12th November, he was operated, and he was discharged on the 14th, advising rest until further advice.
Yes.
The petitioner could not produce any further medical advice and overstayed on his will till 8th of December. What
Yes.
were you doing thereafter?
Yes, he was
Where are the
advised rest.
documents?
He was advised complete rest, my lord. Kindly have a look at the prescriptions of Desun issued from the Desun hospital, my lord. For post, my lord, the page 26 is the gallbladder surgery. Thereafter, he
21st November 22 and 5th December 22. Where are these two documents? Certificates?
my lord, page 27.
27.
Page 27. Thereafter, my lord, page 31 and 32.
21st of December. 21st of November. Rest for 2 weeks. And 5th of December?
5th of December is at page 31.
31.
And again, he was advised to for rest till 12th December, but he decided to go to the to join the battalion. Now, kindly have a look at page number 32. It was decided on 5th of December that rest for 1 week. Page 32. This is the back side of the prescription.
Yes, what will be your submission?
My lord, matter is my knowledge. My lord, earlier occasion, my lord, matter is territorial jurisdiction is already matter dismissed. And they are further notice.
Had submission made on behalf of both the parties. List the matter for orders on 8th of April.
Much obliged.
Give your name. Put down your name. Yes.
I am strictly.
My lord, I am for the petition. I am paying for only for 1 day accommodation, my lord. And counsel for the who is arguing that he is out of station, my lord. I will feel it tomorrow, my lord. Mr. HON'BLE Kumar is appearing on behalf of the SBSTC. I will inform him, my lord. He is not appearing.
An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Released on 6th April. Yes, petitioner is not here. Dismiss for default.
Sure, for the petitioner. Lordship, on the last occasion, Honorable Justice Arindam Mukherjee passed an order dated 6 January 2025 and give the petitioner liberty to add a party. So subsequently, the party was added and served the copy. Lordship, my humble submission is that I have served the copy, but the affidavit of service is not ready. So, Lordship, kindly give me liberty to serve again and come back.
None represents the respondents. Stop. Released on 6th April. Stop service in the meantime.
Grateful, Lordship.
Next.
Mr. Bishas is appearing for the petitioner, Lordship.
Yes.
He is physically not well, has not come to court, Lordship. I am praying for accommodation. Can it be taken up on Friday, Lordship?
Who is your other side? No idea.
No idea.
6th. On the prayer. 6th. Service in the meantime.
Grateful, Lordship.
Item number 119.
My lord, Mr. Surojit Samanto is appearing for the petitioner. He is not present today. My lord, I am praying for not today.
Not today?
Yes, ma'am. He is not present.
Adjourned on the prayer, 6th of April.
Grateful, ma'am.
Number 191.
191, my lord, I am paying for the petition.
Yes.
My lord, here the allegation of the petitioner is that the petitioner, my lord, joined as a LDC, my lord, under the judgeship of Jalpaiguri in the year 1994. And from 1994, only one promotion has been given to the petitioner. And petitioner entitled to get the promotion for supervisory post from 2004. My lord, there was no my lord, senior employee over than the petitioner, and only the petitioner is the senior most candidate. Do not get the supervisory post in spite of specific notification given by the finance department. And from 2004, the petitioner is depriving for enjoying the supervisory post. This is the only allegation. Several representation has been made before the authority concerned, that was not considered. And in earlier occasion, there was a direction given by this Honorable High Court to file report and exception. And report has already been filed by the Chief Administrative Officer, District and Session Judge, Jalpaiguri Court, and a reply has already been submitted.
I can see your reply, but where is the exception?
Exception, my lord, that is 2 pages exception. That is only the report. My lord, there was no report in the form of affidavit, nothing. Only 2 pages report. That is the only report of the Chief Administrative Officer. That is 2 pages.
Oh, this 2 pages.
Yes.
What does it say?
But they said only two grounds against me. That is one complaint made by the another employee. For that reason, they are not given the supervisory post. One, and they here they highlighted one notification, one rules, that is West Bengal Service Determination of Seniority Rules 1981, that was not applicable at all to me.
But then no formal rejection of your prayer is there.
No, nothing.
Where is your application seeking promotion?
My lord, that is application seeking promotion. That is page 41 onwards. And cash benefit also not given by the authority concerned. Only 8 years benefit has been given in the year 2002. 1625 that was not given to me. And supervisory post was not given, though I am entitled from the year 2004.
Please come. None represents the respondents. Step. The petitioner claims that he is in service as a permanent employee in the judgeship of Jalpaiguri. Stop. He joined service on 20th September 1994 and has put in satisfactory service for a considerable period of time. Stop. He claims that the career advancement scheme benefit claims that neither the career advancement scheme benefit or promotion has been given to him. Stop. Several representations have been made by the petitioner before the learned district judge. Stop. None has been answered till date. Stop. Paragraph. It appears that the petitioner attained the normal age of superannuation on 31st of January 2025. Did you get your terminal dues?
After 5 months, due to pendency of this writ application, they did not. One legal notice has been served, then they disbursed.
What, you are getting pension?
Only pension.
The
Nothing.
career advancement and
Nothing. No promotional benefit, nothing.
Achha.
And I am, my lord, guided by page 38, the notification issued by the finance department. Page 39 is the relevant portion.
The petitioner relies upon the notification of the finance department dated 30th March 1984. Annexed at pages 38 to 40 of the writ petition, in support of the submission that he would be entitled to the what benefit? CAS or what?
CAS benefit as well as supervisory post.
The career advancement scheme benefit and benefit of promotion to the supervisory grade. কি চেঁচাচ্ছে বলুন তো? কি চেঁচাচ্ছে? From the documents available on record, it appears that the Chief Administrative Officer has forwarded a note to the learned district judge on 5th of March 2024. The authority has disclosed that as the merit-wise common gradation list of the typists/copyists has not been prepared. Accordingly, the claim of the petitioner for promotion would not be considered. Stop. The report of the Chief Administrative Officer also mentions that the petitioner was provided the first MCA benefit in the year 2002, and he was promoted within bracket functional to grade 1-1 Bengali typist / copyist on 12th March 2010. Since he was given the benefit of first MCA and also given functional promotion prior to completion of 16 years of continuous and sufficient service, he was denied the benefit of second MCA. Top paragraph. Be that as it may, it appears that a formal order either accepting or rejecting the claim of the petitioner for grant of benefit as mentioned herein above is awaiting. Stop paragraph. In view of the above, the instant writ petition stands disposed of by directing the district judge, Jalpaiguri, to pass a reasoned order on the prayer of the petitioner in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order, and communicate the same to the petitioner immediately thereafter. Stop. Learned advocate for the petitioner is directed to forward a copy of all documents in support of his claim to the aforesaid respondent at the time of communicating the order of the court.
Malad, instead of 12 weeks, Malad, some Malad already.
See, they are already involved in the SIR proceedings. It will not be possible.
Opportunity of hearing, Malad.
Achha. An opportunity of hearing shall be granted to the petitioner prior to passing a final order in the matter.
Grateful, Malad.
I don't know 178 possible matter.
My lord, first of all, my lord, I tender my unconditional apologies, my lord.
Yes.
I tender my unconditional apologies, my lord. My lord, this matter is regarding a compassionate appointment. My lord, the petitioner number one's husband died in harness in the year 2000.
Who is for the respondent? Pinaki Bhattacharya, Tanushree Pal Chaudhary, none present. I'll take it up tomorrow. Give them a notice. Tomorrow it will be taken up.